Item number 1, pronouncement of judgment.
Okay. Dismiss this.
Acknowledgement.
Any mention?
At least, Your Lordship. Your Lordship, beg to mention item number 21, Your Lordship. If Your Lordship can have this matter after 2 weeks. Conducting counsel is not in station, Your Lordship.
Which Mr. Nongri?
He's on leave.
Who?
Mr. Nongri is on leave, Your Lordship.
As we may see. As the arguing counsel is on leave, it's a matter of 2 weeks. Yes. For the petitions on leave list after 2 weeks. Yes.
Similar prayer for item number 24, Your Lordship.
Your objection?
No objection, my lord.
Yes.
Acknowledgement.
Please, Your Lordship. Lordship, beg to mention item number 17, Your Lordship. The matter become a top after 2 weeks, Your Lordship. The conduct of counsel.
17 is the Mintru matter?
Yes, Your Lordship.
Why? Where's Mr. Shongwan?
And bereavement, Your Lordship.
Bereavement?
Yes, Your Lordship.
Oh, as our counsel says, bereavement is after 2 weeks. Yes.
A similar prayer for item 27, Your Lordship.
Item 27.
This matter will come after 2 weeks, Your Lordship.
After 2 weeks?
2 weeks.
Yes. Here for the other side?
Yes, Lordship, for the state.
Yes.
All right, Lordship.
Item number 2.
Yes.
May it please, Your Lordship. Lord, this is a writ petition against the order dated 28/5/2025 passed by the one-man election tribunal, my lord. My lord, what had happened is that the respondent number 4 to 6 herein are the ministries, my lord. They had challenged 4 to 6, my lord.
What are the ministries?
The other ministries, Baswell, Nongneng, Shanpru.
Am I able to take up this matter?
My lord?
Am I able to take up this matter? Or?
My lord have taken up the other matter also regarding same matter.
So Dingo, I don't think I'll be receivable this matter, no. It's MLA matter.
I don't think so, my lord.
Yes.
You can go ahead.
My lord, what had happened is that they had, against my election, my lord, they had filed a writ petition before this honorable court, my lord. My lord, after pursuing with the matter, the respondent number 4 to 6 had withdrawn the writ petition with a liberty to approach the tribunal, election tribunal, my lord, against my election, my lord. On the basis of that, my lord, this honorable court, by order dated 17/2/2025, Annexure 10, was pleased to allow, my lord. Page 93, my lord.
93.
93, my lord.
Yes.
The operative part will be, my lord, page 96, my lord.
Yes.
As to the latter part of the prayer made, considering the fact that this matter has been pending for quite some time before this court and also on perusal of the reference made by the learned counsel for the petitioners in the case of so-and-so, this could allow the prayer made thus directing the election tribunal to consider
This
the
is a petition file challenging the election.
My lord, this is your lordship's order only, my lord. This James Shangrai, my lord. So, my lord, after this, they have filed a petition before the this council, and one-man inquiry was constituted, and the tribunal, my lord, and that was constituted, and there was a delay of around 730 days, my lord. In preferring the
What's your
petition, my
prayer
lord.
here?
Well, my prayer is that the records may be called for, because, my lord, without considering the numbers of days, and
Where's the order condoning the delay?
my lord, that is at page annexure 15, page 131, my lord.
You've discussed.
No, my lord, nothing has been discussed, my lord. Lordship, it's very
Where's the finding?
my lord, the finding is at let's see, comment 141. Paragraph 14, my lord. Page 140, my lord. Furthermore, while the delay of 730 days is indeed substantial, this tribunal is of the considered opinion.
Paragraph 14.
Paragraph 14, my lord. Page 140, my lord.
Yes.
Opinion that the time spent by the petitioner before the Honorable High Court in prosecuting the writ petition explains a significant part of the delay by the petitioners in filing the election petition, which clearly indicates that there is no deliberate inaction. or
Yes,
malfeasance.
Mr. Dino.
My lord, this is a private dispute essentially, but I would just want to draw your lordship's attention to section 6 of the Act, Milliam Act, page 320. My consideration is whether an appeal will lie to the executive committee against such an order. My lord will see 6. If within 30 days
So
of
is that which Milliam Act suspension?
Milliam Act 320, my lord. Page 320.
Yes. Yes.
6.
Yes.
If within 30 days of the declaration of the result by the returning officer, any dispute arises regarding any matter relating to or connected with the election of the same, the party or parties concerned shall by a petition refer the dispute to the tribunal constituted by the executive committee for the purpose. The tribunal shall dispose of the matter as early as possible and shall not ordinarily exceed 6 months from the date of the receipt of the case records, which reports and findings shall be submitted to the executive committee for its final decision. So, my lord, the final decision rests with the executive committee.
No, this is regarding final disposal, Mr. Dino.
Yes, yes.
Yes.
But this is a interlocutory order. But even then, if they are aggrieved, of course, I'm raising this as a academic issue regarding condemnation of delay. My lord, I have nothing much to say because this is a private dispute.
My lord, similar matter is pending before your lordship for final hearing, my lord. This is Alban Fredericks AM. If you remember, if your lordship recollect, in the same petition was filed for 43 days. That was disallowed, my lord. Your lordship will annexure 16, my lord. Same tribunal,
We
my
should
lord.
notice then.
You should notice.
Yes, sir,
Records
Mr.
may be
Al-Karim, we'll examine it. Legal counsel with the petitioner. Issue notice. Mr. T. Counsel with so and so. Present except on behalf of 1, 2, and 3. Notice issue to the remaining respondents within 3 days. Stop this after 2 weeks.
Along with this.
Pendency. You have interim prayer.
My lord, records, otherwise record may be called for, my lord, from the tribunal.
No, record not necessary.
Records are not
Can be state, my
necessary.
lord, then can be state, my lord.
Huh?
The impugn order may be state, my lord. 28.5.
You have not made interim prayer.
My lord, we have made, my lord. In this case also we have filed, my lord.
Oh. Yes, this after 2
Miss
weeks.
case 98.
Miss case, this, I miss case, miss case 98. Now this application has been filed for stay of the impugn order dated 28/5/2025, passed by the one-man tribunal in application number 364 of 2025, condoning the delay of 30 days in preferring election petition number 1 2025. Mr. Al-Kiriam, counsel petitioner, has submitted that the petitioners agree with the order of condemnation, which is being challenged in the amended petition, in as much as without there being sufficient cause,
My lord.
that delay has been condoned. So, Mr. Leading Law appearing for the response 1, 2, and 3 submits that's essentially private dispute between the petitioner and the private parties. And at this stage, you won't file any affidavit.
No.
At this stage, also no objection be necessary from said respondent. Let issue notice on the notice issued interim prayer also.
4 to 6.
Respondents. In the meantime, prior to next date for the proceedings in election case number.
Election case number 1, my lord.
Number 1 of
2025.
25 shall remain status.
Election petition, my lord.
Election petition.
Obliged.
Item number 3.
May it please your lordship. The petitioner before my lord is the sixth semester LLB student, my lord, pursuing his law graduation from Shillong Law College, my lord. My lord, from semester 1 to semester 5, he has never been debarred for want of attendance, and he doesn't have a back paper, except for now, my lord. 2025, my lord, the session starts from
Where's the attendance sheet?
the attendance sheet is at page 28.
For the month of
February 28, my lord. February 20, page 28 is the attendance sheet for
23%.
my lord.
Then
My lord, then comes for March. For March, he has got 63%, my lord. And then for page 30, for the month of April, my lord, he has got 78%, my lord.
so overall, what's the percentage?
Overall percentage, my lord, for these, he is coming 47%, my lord. Over 47%. But, my lord,
Earlier semesters?
I'm sorry.
For the earlier semesters 1 to 5?
1 to 5, my lord, there's no issue, my lord. He has never been debarred.
You have not annexed that.
No, I have not annexed, my lord, because he has never been debarred, my lord, in those, my lord. Now, my lord, again for the month of May, for those students who fall short of the attendance, my lord, they were given an opportunity. I have appeared all the classes, and then, my lord, my attendance from 47, it has climbed up to 57, my lord.
Where is that?
57, my lord. That is when in my application, my lord, may kindly look at my application. Where was it?
You have to have 75% attendance, correct?
I'm sorry.
What is the cutoff? 75%.
60%, up to 65%, 75%, my lord, is a BCI, is a college, but BCI says 70, my lord. BCI says 70. But here, my lord, but in this, my lord, I have a very genuine reason, my lord, for being absent in the class.
Where's your medical certificates?
My lord, the first one is, can you look at page 16, my lord? I just explained why there's shortage of attendance. Page 16.
Where's your medical certificate?
My lord, medical certificate, page 22. But before this, but this is only one ground. But the bigger ground, my lord, is at page 16, my lord.
Yes.
Before that, kindly come to page 16 first, my lord. I'll just explain from there. Now, my lord, the classes for 6th semester, February is the month where they have full classes, my lord. And in this month itself, unfortunately, my lord, my elder brother passed away, my lord. So I have, before going home, my lord, to witness his funeral, I have written a letter to the principal, my lord, requesting that my elder brother has passed away. Kindly grant me at least 10 days of leave. I have written this letter, my lord.
1 week.
Yes, 1 week, my lord. Now, my lord, thereafter, my lord, I came back, and then, my lord, I was not able to overcome the loss of my elder brother. And, my lord, one day, very candidly, I must admit, my lord, I was drunk, my lord. I was drunk because I could not overcome my brother's death. And I met with an accident, my lord. So I've written later on, my lord, page by page 19 also, I've written to the principal, my lord. In an unconscious state, I was admitted in a hospital, but of course, by administering first aid, and I was discharged, and I've returned to a
But he's
principal.
already in Shillong that time.
Yes, my lord, because he has already come back. This
He
happened.
attended classes after 10th to 22nd. He attend or not?
My lord, yes, he had
He
attended.
attend the classes from 10th to 22nd.
Yes, my lord, he has attended in between.
Where do you show that?
My lord,
Because see, this application is,
yes,
it says that I so
yes,
on 22nd on 7:30 p.m. I've incident happened to me. I have accident at Road Archival Bhavan at
yes,
Shillong.
yes,
Due to head injury, I am unable to attend the class regularly.
yes.
Now, when he come back on Archival after the
In
demise
between,
of the brother,
yes, I've
he attended
attended.
classes.
Yes,
Where is that?
my
Where
lord,
is that?
I might just say, my lord, because of this, my attendance, because the
You
proof
want to
of
say after he came back, he was drunk for 10, 15
no,
days?
not like that, my lord. He attended the classes, my lord. That is the reason why at least my 23% of attendance has also climbed, my lord.
In February.
In February, my lord. If had I not attended any, then it will be zero or less than 10%, my lord.
Yes.
So, my lord, and then
Hospitalized also.
hospitalized. I wasn't hospitalized, but my face was in a very bad shape, so I could not go to classes, my lord. And up to first week of March, I could not go to classes, my lord. I've just shown the picture, my lord. But I must very candidly admit, my lord, I was in an intoxicated stage, my lord. So I humbly pray, my lord, allow me to sit for because my
Still
final.
UCC.
No, my lord, because here what happened is because I was taken to the hospital in an unconscious state. So they thought that it must be a UCC student, my lord, because Arunachali students a lot their side also. And so say they thought in that way, my lord.
You were alone when you had accident?
Yes, I was alone, my lord.
So you came from Archival Bhavan.
Some good Samaritan, they phoned 108. That is how they've taken me to civil hospital, my lord.
See? Yes.
So, my lord, this is
Now
my.
still police case still going on.
There's no police case, my lord, in this.
Registered will be registered the police case if we have an accident, not a police case, criminal case per se. But anyway.
My lord, no, because I don't know how met with an accident, but
So 57%.
my
Yes.
lord, 57, my lord.
Same,
Here, regarding the attendance, the college can say. I don't think my lord
where's
copy has been
where's
served on the
such a
college.
quality?
We have some.
But as regarding auditing,
I'm sorry, but the college has not contacted me today.
served.
We have served a copy to the principal, my lord.
And the other thing, my
Who's the
lord,
principal?
RC 17. RC 17, we conduct the exam, my lord. 70% relaxable. And my lord, now Pandora
That's
back.
the same in many cases.
Yes.
Let's see, one thing you inform the college, we'll take it up
Tomorrow.
after some time.
After some time, my lord. Yes.
Let it be,
Because
the
Wednesday is the
principal,
exam.
yes?
Wednesday is the exam, my
Yes, let
lord.
them come after 1 hour.
1 hour, my lord. Obliged.
Otherwise, I don't want to
We'll
pass
inform your lordship.
court, huh?
We will inform. We will
Petitioner.
inform.
We don't want to pass orders in absence of the
My lord.
principal, someone from Sri Lanka
Yes,
Law College.
yes.
Obliged.
Item number 4.
Yes.
Mid-
That's for admission.
Yes, Your Lordship. Your Lordship, on the last occasion, was pleased to call for records of former suit, title suit number 19 of 1982.
They've been received.
Beg your pardon.
It's on 227.
Yes, Your Lordship. At first
Those
instance,
MAS. 2 years.
at first instance, Your Lordship, I've challenged the maintainability of the appeal. As it was filed on the
You ready today? Mr. Nokpa?
It's okay, Lordship.
Yes,
My
start.
prayer is very simple.
If you let him start, he's telling you mentality.
Okay, Lordship.
Yes. Maintainability. Why?
Your Lordship, I'm challenging maintainability for the subject matter which he has filed
You
for.
are the plaintiff.
No, Your Lordship, I'm the respondent.
You are no in the trial court.
In the trial court, I'm the defendant, Your Lordship.
I'm the plaintiff, Lordship.
You're the plaintiff.
In the former suit, I'm the plaintiff, Your Lordship.
Sunil Khungur, yes, Sunil Khungur. Yes. In the former suit, yeah?
I'm the plaintiff, Your Lordship, which is title suit number 19 of 1982.
Yes. 82.
Yes, Your Lordship.
You decided conclusively.
It decided in my favor, Your Lordship. The suit is decreed.
That is different matter altogether.
Oh, that time only streamed the same, but
Yes, Your Lordship.
same or this title suit. No. Let's see the old one. This is.
Lordship, that 1982.
82 come there. 82 है ना?
Lordship, that case, that TS of 1982 was regarding the paddy field. But
One second. Let's see the old lane. Disposed of since when?
2nd November 1992. And no appeal was preferred, Your Lordship, by the defendants.
because that was in connection with the paddy field, Lordship. But this present case is regarding a small portion of land.
I want to see the parties in this old title suit. Now, Mr. Nokhlau,
Yes.
you stepped in whose shoes? This suit 1982 was instead by Miraculous Jirwa, who's the respondent now.
Yes, Your Lordship.
Correct. Now there were 4 defendants.
Yes, Your
Now
Lordship.
who are you? Who now this
I,
is Sila Jirwa.
I did not contest at that point of time, Lordship.
It's the defendant number 4, Your Lordship. Principal Kongwir.
Principal
I did not take
legal
part.
heir.
Yes, Your
Yes,
Lordship.
Lordship.
It's the mother of the present appellant, Your Lordship.
I did not contest, Lordship, because
Why?
that case was regarding the paddy field, and according to the appellant, the mother of the appellant has lended 35,500 to the relative of the respondent. So by mortgaging a plot of land, small plot of land. So Lordship, that then it was for a 10-year period. 10 years period was not yet over when that case was filed.
No, one thing, Mr. Nokhlau, just to because see this order, this 3rd November 1992, none of the defendants appeared when the title suit was decided. So 1992, the suit was decreed in their favor, correct, uncontested.
Unconsidered, Lordship, that was in connection with the larger, bigger land, including a paddy field, Lordship. But my land, the suit land
So
is.
that's why we'll see what is the schedule in this original suit, and whether the new suit we're seeking to file now, it's no part and parcel of the earlier, because nothing was, for setting aside the expiry decree, nothing was filed after that. Nothing was done by predecessors.
Right.
They didn't file.
No, Lordship.
No. So the decree became final. Since 92.
Lordship.
There were no proceedings.
No, Your Lordship. Your Lordship, the subject matter in the former suit, 1982, Your Lordship, the entire issue involved is with respect to the paddy field and certain shops involved.
We want, that's what.
And presently, Your Lordship, the appellant.
That's why we call for the record
Yes.
of the old title suit to see whether the new, suit, the fresh suit that filed by Mr. Nongkhaw's client, is part and parcel of the earlier suit land.
No,
That's all.
Lordship.
If it is, then he has no case. If it's not, maybe he has a case. That's
Let me clarify on that, Your Lordship.
It's not part and parcel.
Your Lordship, the subject matter in the former suit is with respect to the entire paddy field and the shops. And the shop standing there, in Your Lordship, which is part of the schedule of the paddy field, Your Lordship.
yes.
And Your Lordship, the paddy field, the shops was under the occupation as a tenant by the present appellant and by the deceased mother of the appellant. So they keep on paying rent, Your Lordship. And then the shops got gutted sometime in the year 2017. So, Your Lordship, the case was withdrew, the eviction suit, and later on the defendant, they filed the appellant here in Lordship, they filed the present suit. So the observation which was made upon examination of the record by the learned trial court, Your Lordship, at first instance, they have made observation that the shops were part and parcel, which they claim as a suit land, is part and parcel of the land which was already been decided in the former suit.
No, he says paddy field now, no shops.
It's a shop, Lordship, by the
See, now,
roadside.
see,
Yes,
one
Your
thing,
Lordship.
you saying paddy field, you saying shops, Mr. No. It's good trying to understand. Shops or paddy field?
It's
It's
shop.
contention now. Shops. Just not said paddy
It's
field.
a land. It's a small plot of land by the roadside. It's not a paddy field, Lordship. But that case of
That case
1982.
92 is only
That was
paddy field only.
paddy field.
No, Your Lordship, that's misleading. Lordship, may kindly refer to the judgment.
See, no, I'm reading the plaint. You see, the plaint says that the plaintiff, the owner of paddy field, Umsning, Shillong, Guwahati Road, which the plaintiff inherited from her mother, the boundaries are so and so, Jakajong Tikaram Adhikari, so and so, CM Adhikari. Oh, he's a lawyer, I think.
Yes.
Yes, next is west, is someone else, then north, south. That's the only thing is, are these schedules still discernible on the ground now?
Yes, Your Lordship.
Discernible, suppose we send a local inspection, is it still discernible on the ground itself?
Yes, Your Lordship.
And the
Presently,
shops are within that, within
there are
that.
no shops presently, Your Lordship.
No shops now.
No shops now.
Gutted by fire.
Gutted by fire, Your Lordship.
No, because then you'll be barred by registrator. You see, that's the only thing.
Now, Your Lordship, in the judgment and order, Lordship, in the order portion of
Anyway, we'll do
the...
one thing, we'll admit it for consideration. Because we
Your Lordship, the other part which I'm challenging on the
maintainability.
maintainability.
Keep it open.
Yes, Your Lordship, but there are no substantial question of law, Your Lordship, involved in the present appeal as well.
Strangely, because they never filed for ex parte decree, they never filed for.
Yes, Your Lordship, they never prefer any appeal or revision or any other application before any higher court.
And both
That-
both
that
below
was-
have rejected your plain rejected by the trial court.
Yes,
In
Your
this
Lordship,
present
there are
suit.
concurrent findings, Your Lordship.
And then appeal also.
Appeal was there, and then
You do one thing, if you prepare, we might try to settle it in the admission hearing stage only. I'll go through the record also.
okay.
Lordship, may I apprise Your Lordship on the observation of the first appellate court, which
But I will just examine myself.
only obliged.
Because if it's then the matter will be very short. If
Your Lordship,
otherwise,
may I apprise Your Lordship on one point which the document that they have relied, Your Lordship, is a document executed between the co-defendant. That is the defendant number 1 and the defendant number 4.
yes,
They ought to have raised a defense or attack at...
records have since been received as requisition. On the prayer, but this is matter when we want it, we'll
After 2 weeks, Lordship.
1 week, Your Lordship.
2 weeks, Lordship.
after 2 days for admission hearing.
Item number
The only
5.
thing is that why no one filed for setting aside ex parte also if you're affected, if you're in possession of that property. If decree had gone against you, now you claim possession, correct? Or no?
They are
You're
not in possession at first instance, Your Lordship, right?
In
From the
first
initial
instance, you said they
stage.
were in possession.
No, Your Lordship.
You're in possession.
Your Lordship, even the present suit also needs to be examined. The subject matter which they have claimed for is for recovery of
I was
possession.
wondering if you're in possession and that you didn't contest the suit when ex parte, even after knowing the decree, you didn't file for setting aside ex parte decree.
Yes, Lordship, in 1982, when
That would have been the correct procedure. Fresh suit now, difficult, yes.
Yes, Your Lordship, but even the subject matter of the present suit, they are claiming for recovery of possession, Your Lordship.
because in the dear Lordship, in the case of 1982, that 10 years period has not yet ended, has not yet over. The land was mortgaged for a period of 10 years, and that case was filed during that period. So that
But we can't reopen that now because that's gone. Should have contested that time. Yes.
I'll
Item
oblige.
number 5.
State, my lord, will be. The affidavit is ready, my lord. We are likely to file it in the course of the day.
I'm praying for 2 days time, Lordship. The client is from Laroes, Lordship. Lordship. Praying, Lordship. Maybe allowed 2 days time.
Your phone number 8.
Yes, my lord, I'm entering appearance for number 7. A matter has already gone ex parte against number 7 on the last occasion, my lord. So if lordship permits, I'll file a small petition to try and vacate that ex parte order.
This after 1 week for the order stop. Mr. Kebaji submits that after behalf the response will file in the course of the day. Stop. Mr. S. Chanda submits that after be filed by tomorrow. By tomorrow,
2 days.
within 2 days. Mr. S. Jindal won't record anything. You file application. Won't record appearance because we file it first for saying a thing.
Item number 6.
Much obliged.
We are filing affidavit today, madam. Please count
Application matter.
arbitration for extension of time, madam.
Oh,
Madam, if it be convenient to your lordship, since the affidavit is being filed today, so it may come up next week or this week.
yes. Dr. L. Mudika submits that after file course of the day. This is matter next Monday.
All right.
Coming Monday.
All right.
7.
Please, your lordship. Lordship, I pray for some more time, lordship, to file affidavit 1 week.
What's the matter about?
Promotion matter. It's a promotion.
Mr. Counsel,
Oh, no, sir.
promotion to?
Inspector Lordship, Taxation Department.
Okay. Mr. Paryat, I want to go and now for further 2 weeks time to file affidavits. Just after 2 weeks.
I'll oblige.
8.
Please, your lordship, I have received a copy of the affidavit, lordship. I may be allowed to file a reason, lordship.
Yes, you are Mr.
J.M. Sangma. J.M. Sangma.
T.M. Sangma.
J.M. Sangma.
J.M. Sangma, like counsel petitioner. Pay for
3 weeks, lordship.
3 weeks time to file rejoinder. Just after.
All I see.
9.
What miscase is this?
Your lordship, this is with regard to the extension of time, your lordship. For the extension of time, your lordship.
Extension of time. Who appeared earlier in earlier occasion?
No one appeared, your lordship.
Who appeared for the in the minute petition?
Mr. Sujit De.
He's aware of the case or he's not been contacted. They've been served, correct?
Yes, your lordship. You
Yes,
filed
sir.
the affidavit, your lordship.
Then application praying for extension of time to consider the case with petition for promotion as directed by judgment order dated 25/9/2024, passed on WPC number 157 of 2023. Top. MS Ibla submits that stop next paragraph. No appearance made on the behalf of the respondent. Respondent number. Sole respondent. How many respondents are there here?
Yes, sole respondent, your lordship.
Sole respondent.
Yes, your lordship.
No appear. No appearance made on behalf of the sole respondent, a sole opposite party, in the case in spite of service of notice. Stop. Accordingly, the prayer made in the how much time?
6 months, your lordship.
How much time it require for the 6 months?
6 months, your lordship.
Yes. Is allowed, yes. Miss case stands disposed of. Yes.
10.
Similar matter, your lordship.
They've been served also there also?
Yes, your lordship. I'll oblige, your lordship.
11.
Please, your lordship. Your lordship, this matter pertains to the termination of the petitioner from his service under the KVK scheme. On the last occasion, your lordship, the union was supposed to receive instructions.
No, it doesn't come.
We will pass orders then. We will pass orders.
Yes, your lordship.
But can you still, are you still get a place to work?
Lordship, as per the instructions from the other petitioners, they have been able to resume their services. So I believe the scheme is still subsisting since then and is still existing till date, Your
They have
Lordship.
to examine it, yes.
Yes, Your Lordship. Highly obliged.
Payment of salary and other things. But I've asked them so many times, they're not responding also.
It's just passing the buck.
Your Lordship, I'm requiring some more time to file my rejoinder, Your Lordship.
How many times you prayed?
Today will be the second time.
Sure.
Yes, Your Lordship.
Yes, for the 2 weeks time, it's still up for joinder.
13,
This matter also I've not been able to receive any instruction.
Please, Lordship, may I make a submission? I think, as per the affidavit filed by the state respondent number 5, they also is asking to praying before this Honorable Court to file a detailed affidavit. Annexed that affidavit filed by the state respondent, they make a submission that praying before this Honorable Court to file the detailed affidavit. Maybe because there is a counseling authority they have constituted, but that is after the admission was over. So maybe they may.
What do you do with the students you have admitted?
Now, Your Lordship, what?
They have to be thrown out.
No, they are still in the class. Now, one thing is that, Lordship, my humble submission is, the case is very clear, Lordship. First, we have been repeatedly approaching the.
No, forget about that. That won't correct that.
No.
That won't correct the what do you call it? The defect.
Yes.
Now you admitted about counseling. That's not allowed.
No, they don't. There is no mention of whether we are allowed or not. They were just completely silent. But once we received the information from the state, state respondent saying that they don't have the state counseling authority. That letter was sent to us. Thereafter, we have approached the NHCM stating that
how will the court correct it then? How can you correct it?
But one thing can be appreciated, the Annex 13, where they have stated that there was a hearing because they said that we have counsel with our own university. My petition, Lordship.
Lordship, the conducting counsel and assistant counsel, they're still conducting counsel and the assistant counsel also, Ms. Alcohol, they're on legs, Your Lordship. However, we've already found.
Who's the conducting counsel?
The conducting, Ms. Ma'am Sherry.
You'll have some time.
Lordship.
Yes. Let them come. Yes.
14,
I've taken steps upon the respondent number 2 and number 3, Your Lordship.
Lordship, I'm entering appearance on behalf of respondent number 3, Lordship, in this matter.
How many respondents are there?
3 respondents.
Still Gujarat? Served?
Yes, Your Lordship.
Served?
Yes, Your Lordship.
So State Bank only. So Gujarat has not appeared.
No, Your Lordship. I'll file my affidavit of service here, Your Lordship.
On?
Affidavit of service,
Be filing after 2 weeks, Your Lordship.
When did you file it?
I'll file it, Your Lordship. I haven't filed.
You have not filed it. Yes, Ms. S. Pandey has entered appearance today on behalf of the respondent number 3. However, there is no representation on behalf of respondent number 2. Though Mr. Pasanthio submitted that they have since been served. He therefore prays to be allowed. And who filed wakalat on behalf of respondent number 2? Okay.
Respondent number 2 is.
Oh, fine.
Director General, Police. You want to speak?
Why you didn't respond to your wakalat? Why you didn't respond number 2 in your wakalat, Nama?
I filed in respect of 2.
Lordship, my apologies, Lordship. My
Tell him to be careful.
Status 3.
Tell him to be more careful because office indicates that the wakalat is written here respond number 2 only.
I extend my apology, Lordship. This is the respondent number 3.
No, number 4. Though office note indicates that Wakalat has been filed. Stop. It is later clarified by Mr. Pandey that inadvertently in the Wakalat Nama answer number 3 some two has been shown. It permitted to correct the Wakalat Nama in the course of the day. Stop. Mr. Parson is also permitted to file affidavit indicating service on respondent number to list after
2 weeks.
2 weeks before the orders. Yes.
Much obliged.
You corrected?
No, sir.
15.
My lord, we have taken steps on the respondents number 2, 3, and 4, my lord. Respondent number 2 is the KHADC, and 3 is the CM of Kairim, and also 4 is the Dorbash Nong, I think Paso, my lord.
You're taking steps.
We have taken steps, my
Anyone
lord.
appearing for them?
No, she is for the state.
And for the state, your lordship, respondent number 1.
They've been served.
It has been served. It has been served, my lord.
You sure?
We'll just see the service report. Or we can wait for the next date, my lord. We'll.
Yes. Also indicates that notice not complete on respondents 2, 3, and 4. This up to 2 weeks for service report. Stop. MS Island was present on behalf of the state respondents.
Much obliged.
Obliged.
16.
Yes.
Item 16, 19 and 20, these 3 matters are relating to land acquisition matters.
3 cases are listed here, my lord.
Yes.
My lord, the contention of the writ petitioner here is, my lord, first is the Section 11 notification issued by the respondent is...
1 second. One second. Yes.
My lord, my first primary contention is Section 11 notification issued by the government, by the respondent state, is not tenable in law and it requires for quashing of the same, my lord. And number 2, my lord, there is no survey conducted, my lord, in accordance with law, and therefore there is no settlement of boundary between the two countries, India and Bangladesh, my lord.
I would only request my friend to indicate in which petition he has placed these facts.
The first writ petition, the lead case, my lord, 496, my lord.
Say that, that's I-496.
Yes. That is the main case, my lord. So, my lord, to pursue it, my lord, the brief background of the case.
That there was Section 11 notification is
not my lord, Section 11 notification issued by the respondent that is available in page number 565, my lord, dated 26 June 2021. Is not sustainable in law. Page number 165. 165. Annexure 38.
Yes.
My lord.
Annexure 38.
My lord. Annexure 38. Is what you call Sangar village, my lord. Now,
Why
the reason, my lord, this was issued in absence of the NOC from the district council. In my take lordship attention to page number 151, my lord, 151. Initially, the district council of KHDC has issued NOC. Subsequently, they realized that the situation is very critical, and the landowners are completely deprived of
151.
151, madam. Therefore, by virtue of this 27 March 2018, District Council has, my lord, withdrawn the NOC. In the last portion, my lord, may I say, read the said no objection certificate therefore stand withdrawn and cancelled. You are requested to kindly look seriously into the undue harassment and ill treatment of the landowners as complained, and please involve this council in the survey of the land. So district council came to know that there was no survey of the land. The landowners are harassed and deprived. Therefore, they withdrew the NOC. Now, when the NOC was withdrawn, they have issued this Section 11 notification, which I have invited Lordship. Later on, my Lord, District Council, again, page number 171, Annexure 40, they have revoked that cancellation order and say that my NOC can be relied on. Page number 171, 1st July 2021. May I read, my Lord? I am directed to refer to your letter under reference to the subject cited above. In this regard, the Executive Committee of the Council Jowai upon the due consideration.
So NOC
Yes.
cancellation withdrawn.
My Lord.
Right. Okay, then.
It is withdrawn.
Yes.
Now that means, my Lord, the NOC given by this council
stands.
Stands.
Yes.
Stands. But admittedly, my Lord, this Section 11 notification was issued when there was no NOC.
Doesn't matter. Yes.
My Lord. That in view of that, my Lord, may I cite the Section 41 of the Land Acquisition.
Who are you?
We are the landowners and the
Your name in the
cultivators.
notification?
Yes, the name is also mentioned.
Yes.
My Lord, kindly see Section 41. Well, special provision for scheduled castes and scheduled tribes. Special provision is provided there, my Lord.
Yes.
As far as possible, no acquisition of land shall be made in the scheduled areas. Where such acquisition does take place, it shall be done only as a demonstrable last resort. Number 3 is important. In case of acquisition or alienation of any land in the scheduled areas, the prior consent of the concerned Gram Sabha or the Panchayats or the autonomous district councils at the appropriate level in scheduled areas under the 5th scheduled constitution, as the case may be, shall be obtained in all.
Just one thing, Mr. Sorry to interrupt. When was the first NOC given?
NOC, my Lord, they did not.
First one.
First one, my Lord, the NOC copy is not mentioned.
When was it granted?
My Lord, it's a. Just come back to that again. My Lord, may come to page number 124. This is the first NOC, 2015, 30 September.
$124.
Well, 124.
$123 is a huge annexure.
What?
Is your annexure? 120, okay. Yes.
It says, well, NOC, with reference subject and your letter cited above, I am directed to inform you that the EC Jowai exercise of power under rules
So granted in 30th September.
Yes.
2015. Okay.
Amended, so they have granted 2015.
Yes.
And they withdraw.
They withdrew on 27/3/18. Yes.
Yes, they withdraw.
And then the Section 11 notifications dated?
Was given on, my Lord, 22nd June 2021.
22nd 6/21.
Yes.
So the withdrawal is 1/7/21. So only 8 days after, 8 days before the withdrawal, they issued notification. That's your contention.
My Lord,
What's wrong with that?
My Lord, the absence of the NOC, they issue that Section 11. Because the Section 21 is very clear. Prior to any notification, it says. That's Section 20.
But it's not an ordinary case, because in this case, NOC existed, withdrawn, reaffirmed. reissued. So
that is with regard to, my lord, the Gender Hills.
Next point.
With regard to, my lord, the East Coast Hills, there is no NOC. If it filed by the district council also.
Yes, next point.
Now, regard to that one, my lord, the affidavit file rejoinder, my lord, I'll come to the next, in the secondary petition. They will have
the first point not tenable because there's no NOC gauge. That's the only ground that should be quashed. There's no NOC from district council. That's it.
That with regard to section 11 notification of the Sangat
no
village.
Survey of land.
Sangat village. Now, may I come to the second point?
Yes.
That requires a relook to the brief background. My lord, may come to page number 60
of the writ petition.
Of the writ petition, my lord. This is a Nehru Noon Agreement they call 1959.
60?
Yes, page number 60, annexure 1. This is an agreement between the two. My lord, relevant portion would be page number 61, the type copy we are in.
Yes.
Censored.
61, yes.
51, madam. It is agreed that the mean of
61.
61, page number 61. It is agreed that the two respective claims of India and Pakistan should be adopted, taking the river as a guide as far as possible in the case of later dispute Ichamati. Number 7 may refer. Sunset River region to be demarcated in accordance with the relevant notification, catastrophic survey maps. On page number 61, Lordship.
61 type copy?
Type copy. Type copy.
Which Roman paragraph?
Roman 7.
Roman 7 says Rian and Surma River region.
My lord, demark in accordance with the relevant notification, catastrophic survey maps, and if there's a record of rights, whatever the result of this demarcation will be, the nationals of both the government to have the facility of navigation to both. So this is the first agreement, my lord. May I come to that, the 1975 agreement. Now they call the concept of, my lord, 150 yards. Now 1975, page number 64. I'm just taking the brief history.
Yes.
This is 1975 agreement, so-called the guidelines. Well, now may I come straight to page number 65, point number 5. It is a guideline between the two when the boundary is unresolved. Pending final settlement of the borders between India and Bangladesh, the status quo as on 25th March 1970 shall be maintained. This does not preclude routine joint inspection by the respective directors of land records and survey and border security forces officers of either country of any portion of the boundary between Bangladesh and India. Wherever boundary pillars are missing or displaced, they should be replaced as early as possible. An inspection of the pillar will be done annually, February-March, jointly by the Border Security Force and the Bangladesh Rifle. All border problem would be amicably settled by mutual consultation as early as possible by authorities of border districts. This is very important, border districts, it relates to the involvement of the districts, border district. The problem, the solution of which cannot be found at the local level shall be immediately referred to the respective governments. Now, may I come to point 8. The border security forces on both sides shall observe the following simple rules to avoid the possibility of unpleasant incidents. May I come to straight away to P. Working boundary may or may not coincide with the international boundary, and its acceptance by both sides will not commit the two governments in any manner in respect of the dual boundary. The working boundary, wherever necessary, will be marked in a simple manner and the limitation shown jointly and record on large-scale maps agreed upon. After the identifiable boundary line, whether real or working, has been fixed, neither side will have any permanent or temporary border security forces or any other armed personnel within 150. It's very important. 150 yards on either side of this line.
Regarding armed personnel.
My lord, I'll come to it. Now they are relying on this.
Come to that. Where is that 100 meters regarding from the zero line?
My lord, they are.
Is it recorded here?
They relied on this. They are relying on this. I'll demonstrate, my lord. if Lordship allow me to read the complete one. No permanent post will be constructed till the final demarcation has been done and problem is resolved. So this maintenance of 150, my lord, is in the temporary nature until final solution is found between the two countries.
Yes.
Now, when we come down, my lord, the point F, Lord, at the bottom line, it will be the duty of the border security forces on either side to prevent armed civilians entering 350 yards stretch of the border, 150 on each side. This is all temporary arrangement. Therefore, we do not challenge also. Now, Lordship, this is the basis. Later on, the page number 82, page number 82. So this is the basis of two countries. There was no final solution, and the temporary arrangement is that 150 yards should be maintained by both sides. Now, page number 82 is the letter written by the collector, and here they have mentioned my lord, may I just refer to
12.
Yes, my lord. Even my lord, point number 8, reproduced by the collector. Depending on the local and ground situation, gates will be erected at the frequent intervals of about 500 meters in distance to enable the public to easily get access to their cultivable land across the fencing.
Yes.
Now, my lord, number 13, in areas or sectors where there is no problem, NPCC will submit proposal on behalf of the MHA to the PC concerned for taking further action to initiate land acquisition proceedings. Well, now, this is the next page. If Lordship can go to page number 82, point number D. Now, the collector has taken this decision. It says that in areas where existing BRO fencing is beyond 150 yards from zero line, survey will be conducted and a map prepared indicating actual possession of fencing. NPCC, in consultation with the PSF State Director of Land Records, Additional Deputy Commissioner and Extra Assistant Commissioner, will verify position on the ground and submit fresh map by such and such. In area sectors free of problem, NPCC will submit proposal on behalf of the MHA to TC for initiating the negotiation process. But this is the decision of the collector, and thereafter, my lord, I will come, my lord. Page number 85. My lord, because the respondent has taken the plea that there is an NGO, and NGO has taken the entire process for right. Page number 85. Since the issue is quite sensitive, it relevance with the right to life of the citizen there, as well as the security of the country, the government has formed this committee. And number 15, representative of CCIP is a collective organization of landowners, NGOs, the lawyers. Yes. NGOs.
Committee on border fencing.
Border fencing organization. It's the NGOs formed by the KSU, the lawyer involved, headmen involved, landowners involved.
Yes.
Now, may I come to page number 95?
What is the purpose of this committee?
The purpose of the committee is to assist the authorities to bring a solution.
Look into the grievances.
Yes.
Yes.
My lord, may come to page number 85.
Page?
Page number 85.
85 you're here, 85, 20.
So I'm sorry, 95. Page 95. And this committee, this is a report given by that committee formed by the government, 95. Then I may come to page number, relevant portion, is a lengthy report.
Yes.
Well, page number 101, report and findings of the Khasi Hills. 101. So point number 2, my lord, findings in the at the bottom. No fencing work have started in all the areas inspected. Landowners, local people, including sirtars and headmen, are not against fencing, but requested the fencing should be as close to the zero line as possible. So the petitioners are not at all against the fencing. They are interested. The only their grievance is that the fencing should be near to the zero line. Now, with regard to the Gente Hills, my lord may come to the next page, 102.8. Gente Hills. Then we come to the next page, 103. The finding is there, my lord. On this stretch, such have been fenced, and it was noticed that in some places, fencing was done much beyond 150 yards from the zero line. And instead, fencing follows the border road. This is one of the findings. And when we come back to at the bottom again, the landowners complain that they are constantly harassed by the BSF while going to the fields. In most areas, it was found that fencing is beyond 150 yards from the zero line. The construction company explained that this is due to topographical problem. So this is the report, and the final recommendation is 105, page number 105. Recommendation of that collective body formed by the government is this.
Yes.
Well, I will take point number 2 and 3, 4.
You are in this place.
My lord.
Where is your place situated, your land?
My lord, here, city number 3, my lord. City number 3.
Your land.
My lord.
Have you made a statement in your petition?
My lord, these are all their villages are fall within this area, my lord, recommended by the authorities. Respondent are not disputing that one. He's an admitted position, my lord. Number 3, my lord, fresh survey to be taken up in areas between boundary pillars and Sansar, Nongchiri to Chalai Kola. The committee is also of the view that in those areas where villages are to be shifted due to fencing, suitable compensation should be made to enable the people to purchase land as well. These are the few recommendations, my lord. Now, when the same is pending, my lord, page number 107, there is a 2011 protocol between the two countries.
Page 107.
107, annexure 10.
Yes.
Well, so I will come to the relevant portion. Page number 109 regarding the Meghalaya sector.
Page number
109. The Meghalaya sector, they mentioned Meghalaya sector.
Yes.
But these are the villages also they have mentioned. And may I come to 1010 regarding Taupi site. Muktabur, all these areas are notified.
Yes.
Well, is it Taupi Tamapil area? The boundary shall be drawn by a straight line joining existing boundary pillars and such and such. The parties agreed to fence on zero line in this area. Now, what I want to, my lord, emphasize is that in certain areas, the authority decided to construct the fencing near the zero line. And some area they want to construct beyond 150. Now, I have no grievance with first, my lord. That is my prayer. But with regard to 7, a second
You are
person.
seeking to overturn the entire agreement that's agreed right from that time, from East Pakistan, then coming here. Now topographical considerations are there with regard to fencing. You're saying that even the fence should be done, forget about acquisition, forget about the claims to owner's rights, should be done on zero line only. That's your prayer.
Now, here, my lord, I'm praying for, my lord, settling the disputes, my lord.
So I praying for settlement of disputes, or with regard to survey, acquisition, or you're concerned saying that the way the fencing being done is wrong.
But I'm concerned with the survey. And while surveying, they finalized the boundary. They did not consult with the local people, the writ petitioners. That is the grievance, my lord. If they consulted local people, they can decide. But here, my lord, behind the back of the petitioners, and I will show the lordship attention to the affidavit filed by the state, they themselves said there was no survey in the presence of the
There's no
landowners.
survey.
There's no survey. I'll show, my lord. I'll try to.
That's your point.
I'll come to that.
You are working on that point because first point is that notification is illegal. Second is there was no survey and the fixation of the erection of the what do you call it? The fencing is arbitrary. You're going to do.
Therefore, my lord, my humble contention is that they cannot construct a permanent structure of fencing beyond 150 yards without finalizing the boundary. I'll come to that one. Boundary is not yet finalized. They have filed an affidavit. In 2015, boundary settlement agreement was signed between the two countries. Now, when we go through that one, there was no concept of retention of 150 yards. I'll come to that one. Because 150 yard, my lord, incorporated in 1975 agreement is temporary in nature. So if 2015 agreements...
Okay, please continue. The next, please.
My lord. So may I travel further? Come to
14.
My lord. Page number. My lord.
What is the meeting in the Bangladesh border fencing, etc., held on 2nd March 2012?
Yes, I'll come. My lord, we come to page 114. This is also minute maintained by the Chief Secretary. Here may I come to point number 2 and 3. The Chief Secretary, ma'am. The Principal Secretary Political Department apprised the meeting, and the problem remains mainly in relation to two stretches. Tauki Chalai Khola, all these shall fall within the 35 kilometers in Jende Hills and Sansat East Khasi Hill district. On account of opposition of the local public and a few other issues, having deliberated issues at length, it was decided that land acquisition proceeding can be initiated for the stretch from Sansat, where there is no habitation within 150 yards from the zero line. The Deputy Commissioner Jende Hill district are requested to take this up with the CICP also. For the remaining portion where single line fencing along zero line may or have to be done in view of the habitation there, PSA was advised to take up the matter with the Ministry, MHA. Number 3, in respect of the Sansat, it was noted that even though on the stretch from Sansat, there was no habitation within 150 yards from the zero line, there was substantial plantation owned by the local people within 150 yard stretch. Therefore, there is strong demand from the local public to have the fencing along the zero line on this stretch as well, so as to enable the villagers to revive those deteriorating Sansat plantation which have been affected badly by regular thefts from across the border. They have suggested to include boundary pillar Sansat within the zero line. These are the, my lord, noted by the Chief Secretary. Here he noted very clearly that the local people are suffering, and it requires to be constructed near the zero line. Now, when we come to the next 116 page, noted by the collector on the ground. So here also collector has noted the similar problem raised by the writ petitioners and other local public there.
Yes.
Now, with this background, till 2014-15, there was no survey admitted. Now, without survey, there was no finalization of the boundary. Now, 2015, they claim that boundary has been settled between two countries. That is available in page number 122, writ petition. Yes. Now it says, anything more than 40 cases of with Indian Bangladesh will start the exchange of such adversely held enclaves from tomorrow, marking the start of it. My lord, page number 122.
Yes, which way?
On the top, my lord.
Ending more than 40 cases.
My lord, Indian Bangladesh will start the exchange of 162 adversely held enclaves from tomorrow, marking the start of implementation of their land boundary agreement. While India will hand over such, my lord, I will come to the bottom, my lord. India and Bangladesh will have outlined the modalities of complex process of settlement of immovable property. The dweller who are hoping to move from one enclave to another country as to proper citizen for the first time since independence will have to provide details of the records and specification of immovable property to the local administration. The details will be posted in the public domain by the administration, and the government will facilitate remittance of sales proceeds.
Yes.
This is the
ratified by Indian Parliament also.
It says, madam. It says. Okay. And now the detailed agreement is available from page number, madam, 123 onward. Now, my lord, can you see page number 123C? I will not take the trouble, my lord, to read all this. But in short, my lord, my submission is that this is the
summary.
My lord. So my humble submission
refers only to 6.1 kilometers of these unresolved enclaves.
Yes. Right. So they said my humble submission is that, my lord, by this agreement, the two countries reached an agreement to settle the boundary disputes. When they entered this agreement on 7 May 2025, boundary is not settled. But on this basis, they decided to settle it. That is number one. Number two, on the basis of this agreement, they have to settle the boundary after conducting a survey.
Yes.
But they did not do this. They never do the survey.
Okay.
And number two,
after LBA also no survey.
No survey. And number two, my lord, this is very important. This 2015 agreement nowhere at all emphasized the requirement of retention of 150 yards.
Yes. It's gone. That's forgotten.
Yes, it's forgotten. So 1975 agreement is in temporary nature. So once they reach this agreement, which they call is permanent, unless they adopt that 75 concept of 150 yards. But 150 yards then Spanish.
Okay.
But
so that's your case.
But so
then how are you affected personally?
Now what on that basis?
And what rights have been
right?
What are your rights that have been trampled upon?
Yes. Now my humble submission is, my lord may kindly see page number 123 Q.
Q.
My lord. The type copy 123 Q.
LMNOPQ, yes.
Well, because this 2015 agreement solely stands on this 1974 agreement. It says that the land
boundary.
boundary.
This agreement signed?
This was signed on page number 123 on 16 May 1974.
16?
May 1974.
No, this type, this 123Q.
My lord.
74.
My lord, what I'm trying to convince is that, my lord, the 2015 agreement was reached on the basis of this 1974 agreement, and they annexed this one in that agreement itself. So 1974 agreement is part of 2015 agreement.
LBA.
Yes, and they call it as a LBA. My lord, may kindly see page number 123Q.
Yes.
My lord, on the top, the land boundary between India and Bangladesh in the areas mentioned below shall be demarcated in the following manner. So this is the guidelines of demarcation of the two countries, which they never carry out. And they say 2015 that the agreement of 2015 is based on this 1947. And if we go by this 1940,
so your submission is that, contention is that, in spite of the various agreements that have been entered into between India and Bangladesh, there was never an implementation of the agreement.
Yes.
And what's being done, the fencing is totally arbitrary.
Yes.
And as per whims and fancies of the state, of the central state government.
Exactly. My lord,
that is your case.
That is my case. Because
how are you personally affected? Now we come to that. Okay, fine.
I'll come.
Your broader fact.
Yes.
We've seen. Now you come to your specific case that this is my land A, and it's been in that manner been taken over without due compensation or due process of law.
Well, for that, my lord, may I come to page number 143. The authorities has invoked urgency clause. Page 143. And my lord may kindly, in persons to this with regard to East Khasi Hills. But
143.
Yes, 143. Showing that the government invoked the urgency clause. Accordingly, my lord, the
140 Annex 21.
My lord, Annex 21.
Yes. This is
These are the
Order
letter
pillar from so and so motion Purdiwa.
that yes, that
your land comes there.
My lord, yes.
Between motion and Purdiwa.
My lord, here in this petition, 11 petitions from the East Khasi Hills.
No. Where is your exact land? That's what the court wants to see. Is in between the motion and Purdiwa areas.
My lord, I'll come to that one, my lord. Notification, yes, it falls in that area, in that site.
No, which area? I mean, when the where's representation, then after this acquisition
my
of this.
My lord, we come to page number 145.
1 second.
Notification. There are, my lord, 45 petitioners are there. I will clarify it and submit before this court. Who are the petitioners? So this section 11 notification was issued on 2nd January 2017.
Where is that?
Page 145.
Okay, it's back. 145.
This too, my lord, East Khasi, relating to East Khasi Hills, there is no NOC from district council. Now,
where's your personal grievance? That's what court wants to see.
My lord, that I make a specific government there.
No, where is the representation made by you? Now you've laid out the history very well. So, see, where's your specific grievance with regard to the, the fencing? That my land, where's that?
Well, here, my lord, individually they did not come forward.
136. To make things short, yes. Where's the petitioner's name?
This is written by some of the petitioner from the Chende Hill side.
This is
but
your
East Khasi Hills, my lord.
Your the application.
Yes.
Yes.
145, my lord, I humbly submit that individually they did not approach. Because the CCIP was dealing with the authorities.
So your only complaints that is not properly, what do you call it?
No survey.
No survey, not properly fenced. That's only the only complaint.
Well, no survey, proper survey has been done.
Yes. That's from whom? Is he one of the petitioners here? Nonglan Pamdhai. Is he one of the petitioners here?
My lord, they are the petitioners. Lordship is looking to page number 160. 76.
Yes.
They are the petitioners here, my lord. Now, my lord, may kindly see page number 149. All throughout, the collector has highlighted. Before I go to their counter,
you paid this cost?
My lord.
99,360. 148. Oh, sorry. 149. Sorry.
149. This is a minute maintained by the collector while sitting with the CCIP. In point 1, on the issue of apprehension on the part of the landowners who may have had land beyond the fencing, a mechanism need to be worked out to enable such a landowner to have any access to their land. Accordingly, Shri Sansach Command PSA will assure that gates will be provided as per practical requirement of the landowners, farmers. Ordinarily, provision of gates is every after 1 kilometer, and in certain cases where villages, houses are located up to 0 line, no house would be shipped.
So that means, Mr. Chari, your grievance is not with regard to that your land has been taken out compensation. Your grievance is that stop fencing until everything is settled, as per the LBA, as per everything.
My lord, that is one
That's
of
the
them.
only thing.
That is the main issue.
Main issue is and fence from 0 line.
My lord.
And let us have access to cultivable lands.
My lord.
That's the thing. It's like a public interest litigation.
Yes, yes. My issue is, Lordship is correctly pointed out. Let boundary properly settle after proper survey, and you take a decision for acquisition. So if you want to acquire it, pay the compensation in accordance with law. And if you want to construct
has been surveyed the land. That's the only question. Has
Yes, my
been
lord.
surveyed.
If your lordship will see, my lord, everything has been done, my lord.
No, we can see everything what been done, but only one basic question: has been surveyed or not?
Yes, my lord. If your lordship will see my counter affidavit, my lord.
I'll come to that counter hit.
Yes.
His counter.
I think that's about
I just
it.
wanted to answer,
My lord, yes.
Your lordship,
If
I
my
just
lord,
wanted to answer
if before learned AG,
Can you see paragraph 12, my lord? Paragraph 12.
One second.
if I just place a few of his affidavit and I will stop my argument.
Well, let him finish. Okay, we'll give you 10 minutes. Yes. We don't want to carry the hearing too far. Yes. Where's the affidavit? Where's
my lord? The affidavit filed by the collector.
Yes.
Chende Hills, my lord.
This is
dated 29 August 2022.
Yes. August
2022.
Yes, yes.
2022.
Yes. Okay. Yes. Yes.
My lord. Now, my lord, we come to running para 12 of that affidavit.
Yes.
They have disclosed the attempt for survey and identifying from 2015. I will not read, my lord. I'll continue to come, my lord, page number 7.
Yes.
Serial number 14. It says a joint inspection was cancelled due to the objection of the landowners led by members of CCIP. Point number 14 in the table. Now 15, in a meeting held with the CCIP NGOs, landowners and village elders, it was resolved that another joint survey has to be conducted within a report will be prepared for submission to Revenue and Disaster Management, while CCIP will submit its own petition of the government. So these are the table, my lord. Now, it was never conducted. Lordship, kindly straight away come to 27 in that table.
Or the affidavit?
In the same affidavit, my lord. Running page 9. Here they said, my lord, notices were issued to the landowners for survey and demarcation.
27?
Point 27 they said. No date mentioned, my lord.
Page 20, page?
My lord, the running page would be page 9. Point number 27 in the table. 27. My lord.
Notice we issued landowners for survey.
Yes, when they issued, they did not mention it. No notice enclosed in the writ petition also, my lord. And they continue, my lord. Then a meeting-based survey department, Government of Meghalaya and NPCC, a timeline was chucked out for the completion of survey and land acquisition processing. During the survey, landowners came forward to identify their lands or crops.
So you instigated the villagers also, 22 and 21, at serial number 30?
30, my lord.
Just read.
My lord, during survey and sunset, Sri Kenching, Secretary of the CCIP, were instigated the landowners to oppose the survey and prevent the survey party from conducting survey. Therefore, the
so you want survey in one hand, and when you want to survey, you oppose it in the other hand.
My lord, here what happened on the ground, it is quite sensitive. The authorities come for survey. One team come for survey. So they want to survey, take the 150 acres. So the local people ask them, okay, you want to count the 150 acres from which area, from which boundary? They say the boundary is finalized. Please show me the permanent boundary pillar.
You don't go to disputed facts, you won't go
yes,
there.
Therefore I am not going that one also. So none of the officer.
The only fact means that you have therefore violated also the SP is required for necessary action because you opposed it. Yes. On October they wrote
one of the person,
yes.
They say one of the person who is the secretary of the CCIP. Now notice given to such and such. Now no survey was conducted. Their own disclosure. If they have conducted survey, they would have identified on that day survey completed. This is a survey report.
No, they couldn't complete the survey because you oppose the survey.
My lord, this is, my lord, the how one person cannot prevent in their authorities.
No, see what's written here. During survey, Amdo village CK Marchang secretary instigated landowners to oppose the survey. So the landowners were instigated by you to oppose the survey. On the ground, you said that look, nothing's fixed, so no survey can be done. So now, where situation such that if they can't do the survey, then what will happen?
My lord, if
At
any
the same
citizen,
time, you say they should be cancelled acquisition or fencing because there's no survey done. Same time, you're opposing it. What will happen?
my lord, if one of the citizen, two citizens obstructing the due process of law, definitely will take this action against those people.
No, not on action. What will happen now? Suppose you oppose the survey also now. Are you opposed or are you for the survey? We recorded that. We record now in this in the course of hearing itself or in the order that you as a petitioner you're not opposed to the survey.
We were not opposed.
You're not opposed. Then
We're
why
not
do you oppose it
If
then at
Lordship-
that time? And now you've come to a court and say that there's no survey.
No, and if Lordship direct for the survey, fresh survey, in presence of the petitioner,
Not
there
that
would
first
be
survey,
evaluation.
but the thing is that you don't object to the survey. That's all. We're not directing for any fresh survey.
Now, therefore, if there is no fresh survey, now how they will go and identify the 150 acres?
They will do their own understanding.
That is
how,
why, my
as
lord.
per the agreements as reached, as per the voluminous communication with Deputy Commissioner, all that's a lot of water under the bridge. Now this court sitting here now can't, overturn everything and say fresh survey. Now overturn the Indo-East Pakistan agreement, overturn that agreement reached with the Bangladesh government in 2014-15 that was ratified by Parliament. So can we overturn that matter ratified by Parliament?
I'm not praying for that also.
No,
I'm not praying for
but
that
the
also.
line of argument is that whatever has been arrived at from all these agreements, no concrete thing has emerged, and so I think no survey has been done. And all those agreements are faulty because you agreed 150 yards. So all those things. Yes.
I'm not assailing the agreement reached by two countries, my lord. But my only concern.
What the court is saying, Mr. Changreso, is that has whatever has transpired afterwards, even regarding emergency acquisition, then the process of survey was in furtherance of whatever has been arrived at to two countries. And so now we understand, like you'll be seeing we small people stuck in the middle, and the thing is that our land's being affected. So all this courts will protect your rights to the furthest extent possible. How your rights will be secured with regard to suppose your land's taken away, you should be given due compensation. That is all. And if the other disputes are larger in picture, that be left for them to settle. The only thing is that you have your respective rights. You're going to lose some land maybe if the border fencing comes through your land, or if it goes beyond to the 100 meters, from the zero line. So now what is the system in place that the BSF has or the government has to ensure that you don't lose your cultivable rights? And for the land that's taken, you will be compensated. The court's going to look to that. We will look at the court of equity. So that's the thing. We're not going to look into this big agreements, this and that.
Agreement, I'm not praying for touching that one.
Now your challenge, there's no survey, okay, fine. And then like section 11, the NOC, that is a material objection. So anyway, that's the only thing now. How you just come down to the brass tacks, how are your individual rights affected? You have come with a petition, how are you seeking to protect it? That's all.
No.
And which part of your land been taken, which you feel will be taken, or because what they want is to let the fencing go ahead in view of the situation that's prevailing now also. Let fencing go ahead, and whatever dispute will remain for adjudication. That's the only thing.
My humble submission is, my lord.
We can't go to the core of everything now and dig out, everything. No, we can't.
Therefore, my lord, my prayer has two parts. My first prayer is, my lord, set aside all those notifications and direct for fair survey in the presence of landowners. That's first prayer. Because the authority
open a big can of worms again.
My lord, that's my lord. That's
Yes.
first leg of my prayer.
Yes.
If they do that one, my lord, my humble submission is that, my lord, the landowners and the authorities sit together. In many areas, they do the realignment. They shift the boundaries. My lord, Writ Petition 27, which I filed the application for withdrawal, her land also, the boundary also shifted through realignment, and therefore she has received the compensation. So that way, my lord, they can sit, if they sit down together, they can reduce the realignment and adjust the boundary.
What length of the area are we talking about? What's the distance of this, of what you're concerned with?
My lord, here, not all the landowners are here, but many landowners are
How much, as per which is before the court now, what is the area involved or the length involved?
My lord, the notification area involved 37 kilometers. It is stretched.
37 kilometers. You are concerned 37 kilometers here.
My lord, not all, my lord, but wherever the land, the Writ Petitioner owned the land,
you have to
concerned with that one day.
Specify which part of your land but you say the boundary is being drawn in a wrong manner.
But that one, if Lordship permits me, I can in 1-2 page identify the boundary number also and place it.
Your Lordship, even in notification, the main petitioner's name does not figure, my Lord.
And I'll come to that.
I don't see his name also.
I'll come to
his name.
No, he's supposed to be the chairman of that CCIB, isn't that right? So,
but none of
petition number 1 secretary.
You're not a politician. Yes.
And my Lord may come to page para 15 of that affidavit.
Yes.
My Lord, on the top for stages in Muktapu, my Lord. They have
yes.
Yeah, on the top. Preliminary notifications such have been sent to the revenue and such. Total length of the such is mentioned. The land in this stage being land. Registered power or attorney executed in favor of the concerned Toloi from other landowner is being awaited. Now, in those notifications, Toloi is not mentioned. He is not the landowner. Now,
where?
Para 50, my Lord.
Muktapu, Lakro, Hawatila.
Yes.
Preliminary notification other sections have been sent revenue bonds. So, when was this sent? Oh, this is the preliminary notification sent. The name will be notified later on. Yes. Then?
Now I'll come to page number 13. That table, my Lord.
Yes.
Number 9-2, my Lord, 15. These 7 villages. The landowner's name is, my Lord, Toloi Ilaga.
Yes.
And in those notifications, my Lord, Toloi is not, his name is not featured. Name of the writ petitions are featured. This is how the government was doing. Because the writ petitioners are expressing their grievances. And now in the second writ petition, my Lord, before I go to second petition, my Lord, if Lordship permits me, first, second, third petition, I will conclude my argument and the respondent may reply if Lordship permits me.
Yes.
And this, my Lord,
just supplement the points, yes, we will note down. But do we have to go through this 150?
My Lord, before we go to the next second petition, may I just draw attention to few annexes in the first main writ petition. Main writ petition, my Lord. The last part of the annexures.
Your first writ petition again.
My Lord. 165. Page number 165.
Yes.
Name of the petitioners are there, my Lord. I will particularize if Lordship permits me. But here, name of the Toloi is not there. He is not the owner. Now,
okay, see, it's confusion with regard to owners.
My Lord.
Then the collector will hold that amount till the right hand owners come forward.
My Lord, I'll show to that one.
Yes.
Pursuant to this, my Lord, we come to page number 171. After that, my Lord, after 165. Wait, 172, my Lord. The objection filed by one of the petitioner also there.
171 is a withdrawal of?
Yes, my Lord. 172, my Lord. The next page, 172.
Yes.
Is objection by the one of the petitioner, my Lord. Point number 1, may I take, my Lord?
Yes.
The Deputy Commissioner's District Wide and such has notified for remeasurement, resurvey of my lands and such. He's one of the petitioner number 2, my Lord. However, no survey team from the TC office has been reported at the site from such and such, my Lord. So he said that you have issued a Section 11 notification before, my Lord, conducting the measurement. And thereafter, may come to, straight away, come to 176 also. The objections are there, but I'll not read the content. They also
See,
have
one thing, Mr. Chari, so sorry to interrupt. It's become a micro exercise which asks the court, can we appoint a commission or something to just so that they can file the complaint, let the Board of Fencing go ahead? Mr. Advocate General, can we do that? We can't
no,
hear
my Lord,
you.
if your Lordship is right, from the beginning your Lordship is asking the locus of the petitioner, my Lord. And if your Lordship will see the prayer, if your Lordship permit me only 5 minutes, I will show.
No, you see, there's a larger, notwithstanding the locus of the writ petitioner, there's a larger, what do you call it, some issues with regard to how the boundary is being drawn. Now, if we understand correctly, is that there's no opposition to land acquisition, emergency, otherwise. Only thing is that they want a fair deal. That's all. That's all. Fair deal compensation if the land being taken, and where we drawn and what rights they still have over that. Some of the land of their part goes into the. That's the only thing.
Yes, my lord. So far their rights are concerned, my lord, we cannot take their rights without paying the compensation. So that part, my lord, there is no issue, my lord. On legal issue, I can't take their land without paying the compensation, or if I take it, I have to pay the compensation. So to that extent, if they have the grievance that land has been taken and no compensation has been paid, my lord, they have the remedy in law, my lord, that they can do it, because they are not, as such, what I understood from the argument of my learned friend, my lord, there is no opposition to the fencing.
Yes.
What they say that if there is no opposition to the fencing, what is being said, my lord, is that if my land has been taken, pay me the compensation, my lord. That issue will be seen by the collector under the Land Acquisition Act. Your lordship protect their rights, preserve their rights, that if on demarcation they have the documents and they show that the notification my land has been taken, they will be entitled to compensation.
We're looking at 1,000 references being made.
Milord, because no, Milord, in only if your lordship will see in the totality, Milord, there is hardly one or two reference, Milord. Even petitioner is not there, Milord. He is the one, your lordship has rightly noted, he is the one who is instigating them, Milord, all throughout, Milord. And he is preventing, and the people are ready to, because in other two petitions, dispute is not with regard to that with the fencing is or my land. They are saying, I am the owner, I am entitled to compensation. Dormar is saying, I am the owner, I am entitled to compensation. For that only, my lord, section 74(2) is there of the Land Acquisition Act. And writ court, my lord, we can't go into all the
We're not going to go into all this.
So therefore, my lord, as on today, grievance is that we have acquired the land in accordance with law. Issue is with regard to who will receive the compensation, whether in terms of, because if the boundaries are erected and they say that look, on erection of boundaries and I am not, my land has, I am not getting the compensation, then they can get the compensation. My lord, these are all disputed questions which lordship may not like to go also, my lord, because therefore all these issues, therefore there is a adjudicatory mechanism, and there will be not 1,000, my lord, there will be only one person, the petitioner, and who is doing it, my lord. Under the law, we have done in accordance with law. Everything, if a lordship will say survey has been done, every step has been narrated in my counter affidavit, how the survey has been done. And this was being opposed by the petitioner number 1 alone, my lord. He has filed the petition and he is also asking, he is saying that compensation should not go to Darbar, my lord. Fine, it should not go to the Darbar, but whom should it go to? That will be decided by collector, my lord. We have no issue, because either way we have to pay the compensation if I acquire the land of the landowner. That right has not been taken away by my lord. So that's a short point which is there, my lord. The lordship has correctly summarized the entire case.
No, try to understand the case of petitioner. I see.
More.
That is why we've heard him very patiently, as what is the grievous, infractions that have happened. Then would have compelled him to come to the court. Yes.
Yes, my lord. Your lordship has, and your lordship protect their rights, my lord. I state will support, preserve their rights, and but permit us to do the fencing and notification. They are also not against what I finally they are saying that fine, we have no issue. Petition number 1 also, my lord, has no issue. He says that compensation, my lord, kindly see section 74. We will deposit the compensation with the collector. Section 74 is clear, my lord, of the Land Acquisition Act. And all these issues, my lord, under 64 also, because what is the area, what is the dispute, all these issues can be looked into by the collector, my lord. Section 64, my lord.
Yes, 64 I've seen, yes.
Yes, my lord. And 74 also, your lordship has seen that. 74 part 2, we will deposit the compensation. And there is a provision of appeal also, my lord.
74 part 2?
No, sorry, that section, my lord, if the identical issue, my lord, in fact, came before before Andhra Pradesh High Court also, my lord, in one of the judgments. And if I can place that judgment, my lord, that may
Give her the
shorten the
judgment.
entire matter, my lord.
Yes.
Andhra Pradesh High Court judgment is there, my lord, on directly on this point. Because in that case also, if your lordship will see that judgment of 2020 SSC online AP 3559.
Yes.
And paragraph 10, my lord. Now, what has happened that 2-3 rounds they came before the High Court. Paragraph 10. In view of the above orders passed by the Honorable High Court, the said writ petition, instead of filing objection before competent authority, writ petitioner with an evil intention filed the present writ petition, questioning the award. It is no doubt that Section 64 of the Right to Fair Compensation Act, with reference to the authority, which reads as follows. Your Lordship may omit. Now, paragraph 11. Section 77 of the said Act deals with the payment of compensation or deposit of the same in authority according to Section 77(2) of the Act. If the person entitled to compensation shall not consent to receive it, or if there be no competent to alienate the land, or if there be any dispute as to the title to receive the compensation, or as to the apportionment of it, collector shall deposit the amount of compensation in the authority to which a reference under section would be submitted. In view of the above position, it is clear that petitioners have any claim, they are at liberty to file reference application before district collector, sought for payment of compensation, or deposit the amount before the authority under section 77(2) of the Act. Even in the earlier occasion, this court has categorically directed the petitioner to approach the authority and file objection, and also for entitlement of compensation amount along with other respondents. Instead of doing so, after passing an award, the petitioner has filed the present petition, which is contrary to the Act. Considering the above submission made by both the counsel, writ petition disposed of the following direction. Petitioners are directed to file a reference under application under section 64 of the Act within a period of 2 weeks from the date of receipt of copy of order. Such a reference authority may take proper action under 77(2) of the Right to Act rehabilitation within 6 weeks and filing of reference till such time and acted not to disburse the amount of so and so to so and so. My lord. So your lordship may pass this direction also, giving that we will not disburse the amount because that issue will be decided. But
that creates
one
more
thing is
problems for
important.
them, because like both the people, he's espousing the cause of whoever, but then if you say not to disburse compensation, some people will not be aggrieved. Then what will happen?
Yes, Milord. So, Milord, if so far as the lands where disputes have been raised in terms of notification, Milord, can you see the notification also, Milord? I just wanted to place that notification also, so that under the Act, Milord, notification has been issued under the Act. Who are the and invoking the emergency? So therefore, they are the ones who can come to the court saying that, or those who are saying that my name is not there, Milord. They are the ones final notification which has been issued, my lord.
Which page?
They can say that I am page. Your lordship will see page 150. That is
150.
there, my lord. Sorry, my lord. That notification is. Lordship will find 165. 165.
65.
165. 165 and extra 38, my lord.
Yes, we've seen that. Yes.
Yes, my lord. And in middle of the third paragraph of notification, your lordship may kindly see. The notification under provisions of section 11(1) read with section 40, right to fair compensation. Emergency clause has been invoked in this case. A plain plan of land may be inspected by the office of deputy commissioner, appropriate government, pleased to authorize the additional revenue. Under section 11(4) of the Act, no person shall make any transaction. Now, this notification is made under the provision of 11(1) read with section 40 of the Right to Fair Compensation Act, my lord. And if your lordship will see, the name of the owners are mentioned, boundary pillars are also mentioned, my lord. Kindly see name of the owner, heart fitting, so and so. These are the, I don't see the name of the petitioner here, none of the petitioners, my lord. Names are here, my lord. And when I invoke emergency clause, my lord, because one of the pleas was taken by petitioner, my lord, that section NOC was cancelled. For that, my lord, kindly see Annexure 22 at page 143, my lord, page 143. 144, Your Lordship may kindly see that part.
Yes, that we've seen.
Yes, my lord. Further, the government under section 40, subsection 4 of Right to Fair Compensation Act directs that provisions of chapter 2 to chapter 6 shall not apply except 11 so and so instant land acquisition. So the section 40 of the Land Acquisition Act has been invoked, my lord. Compensation is being disbursed. And in that light, if your lordship will see the prayer of the petitioner, my lord, in the facts of what have been, kindly see the prayer also. And pleading, I couldn't find much in the pleading, my lord. The dispute is that they say that you demarcate the boundary from zero line. That is what I could get it from the prayer, my lord. Page 55.
Oh, yes.
Set aside the preliminary notification, page 191, dated 22nd June and declared 24th August, so and so and so. So read with section 4, so and so, to the respondent. Now, set aside in class 1st July letter, my lord. Direct the respondent of 3, my lord. Union and state to give reasonable opportunity being heard to petitioner before finalization demarcation within reasonable time. That has already been happened, my lord. That demarcation is, and alternatively, my lord, kindly mark it. Prayer of the following appropriate relief. Direct the respondent minister to fencing within 11 meters from the existing boundary pillar, if pillars had all not been made permanent, and not from 150 yards of paying suitable compulsory return according to law. So their case is, my lord, directly acquire the remaining 150 yards, 11 meters from existing. So they say that if my land falls beyond 150 yards, you acquire it, take it, my lord. Let the boundary fencing take place. Let the notifications which are there already, if they have grievance, any individual who's right, not, it's not a PIL, my lord. It is not a PIL where person can file PIL on behalf of others. They can come and say that my land has been acquired, notification has been issued, I have not been paid the compensation. So lordship is always there, my lord. Lordship can definitely direct the state government and protect their rights also. But what in the garb of this PIL, they are trying to sabotage the entire lordship has seen. He is the one who is opposing the demarcation. That fact has not been disputed, my lord. He is the one who has, an entire process has been followed meticulously, my lord. If I can take your lordship once again to my counter, my paragraph 12 of my counter. In fact, paragraph 10 and 12, my lord, of my counter.
Yes.
Para 10, your lordship, kindly see, I have made very categorical and unequivocal statement in paragraph 10. Detailed on-spot survey was conducted by official of District Commission, BSF and BC in the presence of landowners to ascertain the extent of land of each landowner. All survey work were done after due information was given to the headman through public notice. Any allegations that these surveys were done is false and misleading, my lord. Now kindly see the detailed step and initiative which have been taken at paragraph 12, my lord. Paragraph 12, my lord.
Yes.
First was serial number, my lord, 2005. First meeting with headman was held to declare intention of and explain the components relating to construction of IPPF. Consensus was that landowner would be present during the survey and demarcation of the proposed IPPF. Second, 1/9/2005, since the first initiative was to acquire land in the composite Jantia Hill district, directions were issued to apprise to Lois headmen, concerned landowners and genuine interested parties relating to the matter of IPPF. Third, my lord, on 6 September 2000, a public notice through press release was issued by the Deputy Commissioner, intimating the dates of survey and the components of land acquisition proceeding while inviting all interested parties to be present. Fourth, my lord, Office of Deputy Commissioner Joy, while later dated 6 April 2007, received intimation for suspension of all work. On 20th February 2009, Deputy Commissioner while later dated so-and-so of 20th February 2009 was directed to find solution to the opposed raised by NGOs and to see that works are resumed. 6. 19 July 2012, a meeting was held with the Coordination Committee of International Boundary or CC, an organization claiming to represent the landowners to look into their demands and ensure that there is a cooperation and accuracy during the land. A meeting of CECIT, a resolution was taken, fresh survey for Nongjin to Jalikola in West Jantia Hills. CCI insisted on proper demarcation of boundaries so that people will not lose their cultivable right to property and should not affect the economy after fencing. On 10 December 2014, a meeting with CCBI local headman and resolution was taken to include traditional head as co-opted member to be present during the field inspection.
Okay, anything else apart from this? Other respondents?
This is what.
Yes, other
this
respondents.
Is what I have to say.
Mr. Devnath.
Lucy, we are from the Union of India, so we don't have any role that state is the responsible persons here for regarding these matters. And as regard to the payment and others, you will see already we have given the specific stand in paragraph 28 in my affidavit. You will see.
Respondent number?
1 and 2.
This is which petition?
496.
Yeah. You already made what stand you said? What is the stand?
We given this as a statement made in paragraph 46. The contents of the petitions are false and has denied. The land beyond the fencing can be utilized by the petitioners as proposed fencing is provided with the adequate gate for movement. So you will see.
I couldn't answer. Can you read it again?
Here you will see. As a statement made in paragraph 46, the contents of the petitioners are false and are denied. Land beyond the fencing can be utilized by the petitioners as proposed fencing.
Okay, that is as per the the procedure is there. Yes. Anything else?
And another you will see there regarding the guidelines, it is saying this paragraph 28 in sub paragraph M. In reply to paragraph 46, 15 and 17, it is submitted that these paras do not pertain to the respondent 1 and 2. Further, it is stated that as per joint India-Bangladesh guidelines for the border authorities of the two countries, 1975, no defense-related wars of any nature can exist within 150 years from the IP on the either side. So
that's it.
So this is 150 years it is confirmed.
Dr. Mozika, you are appealing for?
One of the time to district council. District council is only with regard to NOC.
One number.
And another you should just.
One number. In 496.
You will receive another paragraph. This paragraph 16. Paragraph 16 of my affidavit. It is in relation to paragraph 20. As a statement in paragraph 20, your answer is state that it is able from the record that the present boundary is well demarcated and no boundary dispute is pending in the area mentioned in the writ petition. So whatsoever they are saying, the boundary dispute is there. So as per our record, is no boundary dispute.
No dispute.
No dispute.
So what exactly? There's a dispute between the co-owners. No dispute. The only dispute with where the fence is going to come. That's all. Yes.
Lordship, kindly see three paragraphs of Union of India affidavit. They are very critical, my lord. Para 9, 14 to 16 and 28, my lord. Kindly see that paragraph 14, my lord, of the Union of India's affidavit, my lord. First paragraph 9, my lord. First, there is paragraph 9 says there is no boundary dispute between India and India, my lord. Then kindly see paragraph 14, my lord. That regard statement, it is stated that consequent upon signing of agreement on 6 June 2015 by Prime Minister of India and Prime Minister of Bangladesh, border was demarcated. Accordingly, all border pillars have been erected and old pillars were removed. Alleged allegation of petitioner is baseless and in afterthought is hereby denied. 15, my lord. Regard statement in paragraph 19, it is agreed to the extent of acquisition of land of following stretch, my lord. This is the stretch which is being acquired, my lord. And then 16. As regards statement made in para 20, your answering respondent states that it reveals that record at present boundary is well demarcated and no boundary dispute is pending in area mentioned by petition. Allegation of petitioner is baseless, my lord. And this is very, and 28, my lord, one paragraph more, my lord.
He said that, yes. Yes,
Yes,
Dr.
my lord.
Mosika.
Yes.
Only GHDC. Yes. Nothing to add.
But only one thing I can add, the learned AG has placed the judgment of Andhra Pradesh High Court. But here what happened only wrote it appears there is no dispute with regard to the boundary, India-Pakistan boundary. Matter. The only dispute is, it appears because the fencing is to be done at the distance of 150 meters from zero line, the landowners may be afraid that they may not be able to access their land to cultivate their land. My lord, in my humble submission, if that is so, there is remedy for that under the loss of crop and other things also.
You see, what's the actual situation is that they are difficult to cultivate. Once they have to take, they have to go through gates, which put up by BSF, they have to come back by a certain time. Those restrictions are there, so that is, and they're losing valuable cultivable land for which no compensation is being paid.
This is always there in the western border also. People are suffering because of that.
You see, in this matter,
we have gates are provided, my lord. Gates are provided. Adequate gates will be movement. If there is any issue,
28 you already have
mentioned.
mentioned. In paragraph 28, we mentioned about the matters.
It's very simple to see, very simple to say on paper, but you see the nature of the situation there on the border is different. The corrupt only. Anyway, yes. Who else is there? That's all. What up, Mr.
Respondent number 12.
In this 496.
In 496.
What do you have to say?
Your Lordship, I support the submissions made by the learned AG. Apart from that, I just want to state that this survey was duly conducted.
Yes, 112 is the other?
NBCC.
I'm the executing agency, Your Lordship, entrusted with the job of construction of IBPL in Meghalaya.
And supports AG submissions. And number 2, what is the other submission? Survey of duly done.
The survey was duly conducted, yes.
Yes.
Section 77, subsection 2 is very clear, my lord.
Section?
It gives section 77.
Yes, section 70. Yes.
Yes, my lord. That law is very clear on that point, my lord. That gives, and that has been taken note by Andhra Pradesh High Court judgment also, my lord, on that point. So if their rights are not as such, there may be some hardship. I'm not denying, my lord. There will be some issues, but at the end of the day, my lord, we have to erect the boundaries, my lord. And whatever rights are there, that is also protected under the Act, because that will be under section 77, subsection 2, my lord.
And East Khas Hills? East Khas Hills?
No, this is also of hearing. This follow number 11.
Yes.
Here, in regards to the issues of NOC, even in cases of urgency, the state ought to have approached the district council in terms of section 41, subsection 3. You only stating the applicant at paragraph 6.
That is at respondent 11. So first is, let's arc only for number 9.
In 496, state is 49.
Yes, okay, number 9. Here the DC, yes. Separate affidavit on behalf of DC East Khas has been filed also.
Two affidavits were filed in 496 for Collector Joa and Collector
Yes,
East Khas.
you appeal for Collector East Khas Hills, correct?
My lord.
Then what do you have to say?
My lord, in East Khas Hills, my lord, we have brought into record landowners who have received compensation, my lord, and who are part of the compensation. So the entire steps taken by the administration, my lord, if it is not being affected by any private interest holder, my lord, we have been successfully able to encourage the actual landowners to come forward and accept the compensation. And in affidavit of East Khas Hills, my lord, we even enclose the name of the petitioner.
Which para is relevant?
My lord, that will be at page number. My lord, kindly have page 53, my lord.
53
53, my lord.
of your affidavit.
Affidavit of
9. Yes.
My lord, that is the list of the petitioner who has, I mean, the landowners who have actually received the compensation also, my lord. These were the development that have taken place after the writ petition is filed. And those are the subsequent documents, my lord. Lordship, page 57 is the acknowledgement receipt which money has been given to them also.
No, what you have to see on the merits.
So, my lord, basically, my lord, that is the only thing which East Castle.
East Castles here, there's no issue, you mean to say.
My lord, so far as in comparison.
And Mr. Sanglesh is not concerned about East Castles. Yes. See, Sangha, where is the
There is
affidavit?
only issue of compensation, my lord. Who will get the compensation? My lord? That is the only issue in the other two matters.
In the, yes.
In other two matters, my lord, 150 of 2024.
Once again, no, regard to this council, where's the affidavit? What do you have to say?
We have filed on 29/6/2022. We will get it on 9/6 of 2021.
Okay, yes. This papers become a mess, all these papers, yes. 41. Yes, what do we say? Filed by?
By KCDC.
41?
496 of 2021.
Right, 496, respond number 11.
Madam, we have para 6.
1 second. Trying to locate your affidavit. Filed on?
On 29/6/2022.
Okay. Yes, para?
Para 6.
Yes.
Lordship, can we have the section 41?
Yes. Yes. Where are the averments?
Here, our content is that, in fact, the support case of the petitioner with regards to the issues of NOC.
No, where is the averment made regard to that effect? You just quoted this section.
No, my lord, here, we have stated, my lord.
Where? Para 6 just said that applies also.
Yes.
Ought to have obtained. So have you made a categorical statement that means that the entire exercise is invalid? No.
No, we can't say that.
You become fait accompli. Yes. Anything else? Other two matters? ये तो. Just filed by you, Mr.
My lord, seconded petition also.
Yes.
Yes.
Now, what's the next?
Lordship is hearing patiently, my lord.
496.
We will not
The
take
496 is
long time.
over now.
Yes.
Come with the other ones.
156 of 150.
Wo bahan ini? Agak diam. Just take this. One
150, my lord.
Other writ petition,
Yes.
Union of India is not there.
Yes.
Very good. Yes. What's the matter? 150.
But 150 we have assailed
your
the
prayer here?
My lord. Prayer is, my lord, page number 40. 40, my lord.
Yes.
My lord. Set aside in quash impugned preliminary notification of sections and such in section 19 declaration. The reason, my lord, being is, in short, during the subsistence of the first section 11 notification in the first writ petition, section 19.
That's inconsequential.
They have without cancelling that one, they issue the second notification for the same plot of land. I'll just show that notification available, page number 45, 43. 43. And section 90 declaration is page number 48. So this is involved in the first writ petition.
Now, Annexure 1 first writ petition, 22nd June 21.
Yes.
Correct. Page 43.
Yes.
Okay, then.
Then the Section 19 declaration available, page number 49. They have mentioned in the notice.
Yes.
Though they did not give us the copy. But in the with this, it is hereby declared that the landed property measuring an area of such and such, more or less such as Sankat village, the schedule of which is specifically mentioned herein below, is required to be taken, transferred by the Government of India for the purpose of constructing the park where such and such and such and such. In the declaration, they have mentioned such and such and such. So this is a Section 19 declaration. They said they have done it. Now this is the same plot we have mentioned in the writ petition, first writ petition. Now, without revoking, cancelling this first Section 1119 declaration notification, they have issued the another notification. That is page number 100. Well, 113 March, they have mentioned Moktapur, Laikro, Hatiol, Espitela, Sankat village also there. Well, these are the villages. And the writ petitioners, who are the landowner under the paper of the collector in first writ petition, they are no longer the landowner, but the lawyer become the landowner under this. And Section 90 declaration is also page number 106.
Two notifications here, that means.
Yes.
This is 13 March 23, different land. 13 March. This is confusing. Wait, Annexure 14.
It is the same land. Sankat village.
No, now in 22 June 2021 is Sankat village. Okay.
Yes. Yes.
Then in the second notification, 30 March 23.
Sankat also mentioned.
Sankat also mentioned. Jaria
Yes.
Khola, Pasadawar.
Yes.
But how can we know for the same area or not?
My lord, it is now I would take the other paper where they have given. My lord, just my lord, just bear with me. It is there, my lord.
We will continue tomorrow. There are two matters.
Yes.
We will pass judgment tomorrow. Yes. You just come prepared.
Yes,
you
only
can just
that
come
area,
just concise the facts. We don't want
Yes,
to make too much time where we just
Yes.
looking all over the place.
Yes.
Yes. To list for hearing tomorrow is matters. Supplementary list. Tomorrow will conclude.
Yes. Short time. Give me out.
You have the authorities. You kindly bring also.
Yes.
Item 18.
Lordship, I was praying for some time, Lordship, in this matter.
After taking such long leave, now you're asking for time. First case.
Your Lordship, I'm appearing on behalf of the MPSC, Your Lordship.
Yeah. What about 1 and 2?
I'm from
The 1 and 2. Karwan Lang 3. You ready? Dealing door for 4. Yes. 4 is whom? You're a selected candidate. I'm saying I selected candidate, you saying Mr. Deb.
Yes, Lordship.
Mr. Deb is not a selected candidate.
Respondent 4, Your Lordship.
Yes, we'll have it after 1 week. We have some
After 1 week.
difficulty, yes. On the prayer of MS, we are going to do this up to 1 week. Yes.
Highly obliged.
What the matter is?
Yes, sir.
Motion जो you've been.
Second call, item number 3.
You sir, you've
Yes, my lord.
informed the court authorities.
Yes, my lord.
Yes, Mr. Chakravarti, any submissions to make?
First of all, I humbly submit that it's not a matter of discretion of the court, discretion of the principal.
But do you feel the court should show
Secondly,
discretion in view of the candid submission of
Well,
responsible
secondly,
behavior on the part of student?
Secondly,
What kind of message will it send if a student is allowed to indulge in that kind of activities and use an excuse as made in statement at the bar by the counsel petitioner?
and that also, and I am submitting here, Miller, that the period which has been explained by the petitioner, that is 1 week and on the first time, Miller, and on the second time it's 4 days. So 5 and 4, 9 days are explained. So, Miller, the attendance is quite short. I mean, the whole shortage of the attendance, in my humble submission, has not been properly.
When the exams will be held again?
My lord, is day after tomorrow, Wednesday.
No. When suppose you can't sit for the examinations
My
now?
lord, then the next year only, my lord. Next
Not
year.
next year?
I think next semester exam will
Next
be
semester,
six,
my lord.
6 months, Miller.
After 6 months, my lord. So I am. So my lord, in the Bamang Nabam's case also, my lord, if the court, the division bench has very clearly held, my lord, if owing to circumstances which is beyond the control, my lord, then the rules should not be applied at all, or
Yes,
the
okay,
discretion.
fine. That is reading, that is different. But in this case, circumstances of every case
Yes,
looked into
my lord.
consideration.
So
now in this case, what has happened? You went for 1 week, you came back, you got drunk, you had an accident.
No,
That's all. Then
my lord, it's not that. My lord, because
later on, every student say, I got drunk, I fell down, and I couldn't come to class for.
no, my lord, every student's brother will not die, my lord. Kindly appreciate, my lord.
Is fine. 1 week is fine. He's come back to Shillong. He's riding the bike from Anasar Bhavan to wherever he's going. He said he's intoxicated.
No, my lord, there is. We have not stated anywhere that he was riding a bike.
You have made a submission at the bar, Mr. Yuban, the responsible counsel, that he was drunk and he had an accident, and that's it.
My lord, I would like to reframe, my lord. I said he made an accident. I never said that he was riding and he made an accident in a bike.
He was accident, whatever,
my lord,
because he was intoxicated.
My lord, he was intoxicated. That's a very candidly.
Can the court on the basis of submissions, candid otherwise condone such behavior?
My lord, here the question is the absence, my lord. Even if, my lord, okay, do not condone me for the period that has happened, my lord, 4 days. Do not condone me, my lord. Still then, my lord, bereavement in the family back in Arunachal, my lord. This is a very reason ground for a student. And also kindly look at the conduct, my lord. Kindly look at the conduct, my lord. Fifth
Whose
semester.
conduct? His conduct or?
My lord, his past conducts, my lord. Up to 5th semester, my lord, he has never been debarred, and he doesn't have a back paper. This itself speaks volume of the students, my lord, the students' conduct and the sincerity, my lord. Unfortunately, my lord,
Does he have any back papers?
No, he doesn't have any back paper, my lord. He doesn't have any back. That is the reason, my lord, we're saying. If he's only drunk without breathing, my lord, as a counsel, I will not.
Okay.
I will not even come, my lord.
Orders.
My lord, obliged.
Second call 13.
Yes.
Lordship, my apologies when the matter was called. I wasn't available. Lordship has raised an inquiry that what was the content of the affidavit of the state, my lord. My lord, the state affidavit is just a affidavit in which we brought into record a notification, my lord, that we have constituted the counseling, my lord. So only to the extent, and this is for the session of 2024 to 25, and the petitioner before lordships are the batch who are before that, my lord. So they have gone ahead the counselling without
any affidavit from the union has yet anything to say?
They have not.
Any essential inputs?
They have not filed.
What the impune order itself says.
What to do with the students then?
Lordship, students are still the regular class is going on. Your Lordship, my kindly appreciation.
Can it be a post facto counseling?
That will be
for the only may not be taken as a president, but just for the interest of student, your Lordship, what happened?
But this university is repeating the same thing.
No, this is just an allegation, your Lordship. they cannot make such kind of statement because the what?
Why can we such a statement?
Because this is making the repeating. There is actually from our part, your Lordship, from the series of my humble submission before your Lordship is this: since we have been pursuing the matter
Where's
with
the impune order?
The impune order, Lordship, that is in the 6. Before passing the impune order, also there was a hearing, also, Lordship. We have complied with that and we have submitted all the documents also. And no, any order has been passed by the NSCM. Since there was a hearing, at least that one aspect of the matter, Lordship, that they should have.
This was passed in 5th of March. When do you file the petition?
This petition was filed on 28 March 2025.
See, there's no what do you call it, possibility of your students being regularized. What to do?
One.
How long they've started now?
It's already almost about 6-7 months.
So 6-7 months, then you have to rewind the whole thing, admit them next session next year after counselling.
One thing is, Lordship, since
the students haven't come forward, so your action has impacted them also.
Yes.
Is that correct, Dr. Mozika? The students are not to blame. How will you compensate them?
Yes, Lordship. That's
you
why.
still have to compensate them.
Pay them 5 lakhs each.
It's all for money, my lord.
How much money they've got with interest?
Violating all the rules, my lord.
How much? What's the admission consideration fees?
That I have to get the instruction.
There's a file affidavit, my lord, how much they've charged from his student.
You file an affidavit.
For admission and
yes, a proposal to impugn order categorically indicates that there can be no admission into the course without counselling. Stop. From the affidavit of the state respondents, it has been shown that the state counselling agency, what's it called?
Meghalaya State Counselling Authority for Medical Education.
Meghalaya State Counselling Authority for
Medical Education.
Medical Education was constituted only in
on 11 December 2024. That is after the students. After the students represent, after the they're not petitioners. After the petitioner university admitted, before the constitution, before the constitution was before the sorry, getting. Stop. The admissions admittedly had taken place much before the constitution of such an authority, which prima facie makes their admissions not tenable and not tenable as in the eye of law, as per not tenable as per the procedures. Stop. Next one, Mr. P.T. Sangma, the counsel of the picture on this observation of the court. What is your submission? My submission, Your Lordship. The state also, they said that they will be filing a detailed affidavit. That is only the document. In the paragraph, they have categorically stated.
In our affidavit,
No, they have not filed the affidavit in respect of the entire the petition, but they have only bring onto the document.
Passengers have complete instructions and praise that the citizens are directed to file a detailed
And they have
affidavit.
authority also to cite you.
What about you? You're not filing affidavit?
But I'm awaiting instruction, my lord. May I just drop page 80, my lord, your lord's petition.
Read petition.
How much they're charging, my lord?
How much you're charging?
Page 80 will show, my lord. Page 80, my lord, tuition fees, lords will see. State government quota seats. If these were state government quota seats, fee would be only 5,75,000, my lord. But it appears they've all filled up on management quota, charging 30 lakh rupees each.
So what upfront? How much they have to pay these poor students?
And the number of students is 36, my lord. So it's a business of crores and crores, my lord.
No, 36 students. No, how much they have to pay upfront? Suppose to get admission, how much do they have this management quota? How much do these students have to pay?
That
See, the thing is that Mr. Sama, what this court's concerned is, now if you're running an institution, it should be as per the laid down norms and procedures, correct? Now you're enticing the students to take admission and you're charging a hefty fee. How many years is the course?
It's 1 year.
1 year course?
No.
This is a Bachelor of Ayurvedic Medicine.
4 years. 4 years. Course is 4 years. They have determination.
How many years the course?
Page 77 will show, my lord. It's a 5-year course. Page 77.
So 6 lakhs per year.
6 lakh per year.
Oh, yes. Annual quota seats. First year 6 lakhs.
They are bound to give state government quota seats, my lord. It appears they filled up all the management quota.
They have 36 seats. 24, 9 plus 15 means state quota 24, 9 plus 15.
That's one aspect. On the second aspect, without merit, my lord. Because JOSA goes by the merit list, all India merit list, my lord. If the counselling is done by JOSA, my lord, the counselling authority, the seats are filled up on merit as per the all India merit list, my lord. Here, what they've done, they've just called them.
Lordship, let them file the detailed affidavit. They have not even filed the affidavit, Lordship, because now the issue before is not about regarding the charging of fees.
What think about our poor students paying 6 lakhs already now for admission first year? Right, they paid 6 lakhs. Then now all management quota is 36 seats. They fill, and management quota as per the structure is 24 seats. If you see the table.
Well, I do not know how many seats are, because this is their document, my lord.
No, it is. We have admitted 36 students. That is there.
So how many from state quota? How many from management quota?
It's all management quota, my lord. Lordship kindly sees the names, my lord. At page 86. They are studying Ayurveda, my lord. Kindly see the names. Asma Yasmin, Ejazul Ahmad, Nabu Bhushan, Julana Akhtar, Zarifa.
Problem done. Also, we directive file this affidavit. MS Colony, you want to file or not necessary?
My lord, because lordship has only raised a query because this is a batch which which at that time when this entire process started, my lord, we don't have.
I don't think we need a further affidavit from them.
My lord, we do not have any call when
You find an affidavit, Dr. Mojika.
On the last occasion, Lordship have also a query whether they can take a consider in the retrospective manner or that aspect. Maybe
that
they
won't be in their domain. That'll come before this authority only. That is the National Commission for Indian System of Medicine. And they've said that I'm directed to bring a notice that all admissions in BMS should be as per clause 1 of sub-regulation 7 of Regulation 5 of the National Commission for Indian System of Medicine, so and so, which reads as follows: all seats, irrespective of category, central, state, or management, etc., except foreign nationals, are to be admitted through counseling, central or state or union territory only. Direct admission by any means than the above specified shall not be approved. Does not mean not be approved.
But one aspect, Lordship, that
No other
we
aspect.
should have cooperated.
should
Have
have
it been this university, because this letter actually we have been pursuing with them. They never communicated to us.
Yeah. To this submission, MS Arconi submits that as the only relevant aspect is as to the constitution of the counseling authority, no further have to be filed with the government. Correct?
My lord, subjective, my lord, after the affidavit comes, my lord, if there is a
Subject to further instructions received
they have
by
stated in the
some
affidavit,
stop.
that's right.
However, stop as noted that that the respondent's number
They
will
have
clarify
to-
once and for all with regard to the applicability of this impugned letter, whether it can be relaxation. However, as there's no affidavit yet from the
2,
side
3.
of the respondent's number
1, 2, 3, and 4.
State is 5 and 6.
1 to
1
to 4. Dr. Mbosika's please be allowed to 2 weeks time to obtain instructions. 3 weeks, okay. For affidavit. Otherwise,
This will also file an affidavit how much they've collected. They can bring on record.
you come first. If it's not possible for them to be regularized in some way, then we have to refund with interest.
22.
Yes.
Worship, in terms of the last order passed in Miss Case number.
Yes, go to the order column next to it, huh? Yes.
Passed in Miss Case number 86 of 2025, Lordship, the respondents were supposed to bring on instructions, Lordship, with regards to the status of the.
Yes, what happened? Why did you do this?
Yes, sir, Lordship, I got the instruction regarding.
Why was the result declared?
Only this that they kept in abeyance. On receipt of my your
No. Why did they declare the results?
Your Lordship,
Because you didn't inform them.
Yes, it was.
In the first instance, did you inform them about the order passed with this court?
Yes, your Lordship, kindly have a look
You
at the
bring
letter.
correspondence. Where's that?
That order, your Lordship, I have fairly submitted other day, because when the order was passed, I was out of station. I do not know. I came to know only last month. But
So anyway.
the petitioner has already communicated to them that it is under challenge.
We have to record a submission that is due to negligence of the council. Yes, MSS Versaji to submits on instructions that the notification dated 15/5/2025 has been kept in abeyance. Stop. He further submits that the action of the respondents in declaring the result of interview was due to the lapse on her part in not communicating the order of this court
May I
that
please, Your
had been
Lordship?
passed on
Petitioner has already
17
communicated the order, earlier order, 17/12/24.
This should be from you.
Your Lordship, I was
17/12/24.
absent on that day, Your Lordship.
That's too bad. 20/12/24, because always they look
It
for
was
your
a vacation
communication.
bench, Your Lordship. Order was passed in the vacation bench. I was not present in that
Now
day.
the thing is that communicated when 17/12/24. Communicated when this.
Because
The order is of 17/12/24, Lordship.
and last working day was 16/12, Your Lordship. I was not present, and I came to know only last month when I came to know about this case. Miss Case is pending. When I requested Your Lordship that Miss Case is
In consideration, otherwise I would made them stand here. Just consider your submissions. Remember the latitude that this court gives you. Just remember that. In all other matters also. Because your seniority, we allow you latitude. And it's not a question of a young lawyer or something like that. So we can't have that, It's a responsibility of every government council. Then what's the point of being?
Your Lordship, kindly have a look at my.
Should have a look at anything. Let's see. Give me 1 second.
The second line of the letter, Your Lordship, communication letter, that in view of the order dated as the government was informed about the advertisement, informed that the advertisement for the post of child development protection officer dated 27/11/24 shall not be concluded, Your Lordship. It is written on this first second line, Your Lordship.
This is vacation bench 1712.
Lordship, no, Lordship. Last working day of, in fact.
Why is it vacation bench?
Because 16th was the last working day, Your Lordship. 17th I was not present. Mr. Learned Advocate General assisted by Mr. KP appeared, and I came to know only last month.
No, how it's vacation started when Pet Karka last year.
If I am correct, Lordship, 17 was the last working day.
But I
Not
was
16.
not, but Your Lordship, I was not present on that day.
Then where were you? 17th last working day.
Working
Why you
day.
make the excuse that it was a
Your Lordship,
vacation?
kindly have a order. Look at the order, Your Lordship. I was not present.
You're not present, but why are you saying it's vacation?
Sorry, Your Lordship, my
Then
apologies.
why are you making these wrong submissions?
I was not there, Your Lordship. I cannot remember also, Your Lordship, whether I was on leave or not. So, I was not present. Learned Advocate General assisted by Mr. KP was present on that day. I'm extremely sorry, Your Lordship.
With a very.
And even, Your Lordship, another order was passed.
When did you communicate the order to them? Out of order 1712.
Lordship, we in fact have not communicated from our end, Lordship.
You didn't communicate?
No, Lordship.
But the day your senior said that he has communicated.
In view of the order dated 17/12/2024, which appears was not informed to the respondents either by the State Council or by the Council of the petitioner. When do you want to hear for hearing?
Lordship, another aspect, Lordship, is with regard to the draft rules, Lordship, because.
No, when the hearing? Final hearing?
Lordship, next week.
Not a final hearing after
Lordship,
1 week. Yeah.
1 week.
May I please, Your Lordship, another order Your Lordship has passed regarding whether amendment
Finalization
of
of
the,
the rules.
draft service rule. That was also I am waiting instruction. I have written on 30th April, Your Lordship.
Yes.
23.
May I please, Your Lordship?
Yes, Mr. Padak.
My Lord, this pertains to a small procedural issue. Lordship, at page 26, earlier, Lord passed an order that there were uncommunicated ACRs. Against that, my Lord, the petitioner was permitted to give representation.
Yes.
My Lord, thereafter, representation was given, my Lord, at page 28. At para 6, my Lord, I had categorically stated that in these ACRs, my Lord, which were uncommunicated, my Lord, the initial ranking by the initiating officer was recommended for promotion. However, the reviewing officer, my Lord, had downgraded it. Now, in response to the same, my Lord, at page 35, page 35.9Z, my Lord. They simply say that expunging his SCR and reviewing with inflated assessment is not warranted. So they denied to, in a way, review, my lord. That is my limited grievance here, because as per, my lord, the extant DOPT circular in this regard, case 41, my lord, in such cases, the views of the reviewing officer has to be obtained, and thereafter they are free to, of course, take it off. But then this procedure has
See,
not
look at
been
this
followed,
G.
my lord.
Expunging his ACR and reviewing with inflated assessment is not warranted. Stop. As the promotion is given against limited vacancies, the right individual who has earned genuine ACR and has potential promotion in the next round will be debarred if his position expunged whose performance has been below desired standard. More so, his date of superannuation is 31st July 23.
My lord.
Then
they of course say that since I was not qualified and there were other persons.
So now you're retired.
They haven't given the promotion.
And now you're retired. Now you're retired.
No, my lord.
Then?
My question is that, my lord.
No, question just answered is that's why this has been more so date 31st July 23.
My lord.
Then? Just dated when? When's it your retirement? This 31st July, you need a date of your retirement, his order was passed.
He is, my lord, in service, my lord, because in 24, while we filed a state petition, my lord, we gave his.
How is that possible? Yes, Dr. Mosi, how is it possible? He is superannuated.
We've not said anything.
You get instructions 1 week.
I
don't know.
I will also ask, my lord.
How, what is strange? It's strange. Yes. Praise for. Yes, I noted that just now. I noticed that just now that he superannuated in 31/7/23.
I'll take it.
Allow it.
Yes. Counsel of the parties paid without the instructions on the date of superannuation of the petitioner, as reflected in the impugn order that the same is 31/7/2023. Correct? Yes.
Item 25.
Yes, after 1 week.
May I please your lordship? The petitioner here is the unmarried lady of the deceased father, my lord. My lord, the AG office affidavit that they have filed, my lord, in page 6, my lord. If my lord may kindly see.
That is 7 and 8.
Yes, my lord. Well, and it's 7 and 8, my lord. Now they are saying, my lord, that we have not supplied certain documents, my lord. Like, my lord, in page 8, my lord, they have mentioned the legal adoption deed as declared in CR order dated so and so, my lord. This, my lord, this point I need to get clarification from the petitioner. Whereas, my lord, other documents like unemployment and unemployment certificate, income certificate, and unmarried certificate, my lord, we have already submitted. Only regarding this.
Where are you reading from?
Page 8, my lord.
Yes.
Page 8, the last 5th line, my lord.
This is the case, the department has not sanctioned permission and they furnish a real adoption deed for
that legal adoption deed, my lord.
Why you have not furnished?
No,
this?
that is what, my lord, as per the petitioner, my lord. She said that, my lord, that over telephone, my lord, I'm open to be corrected, my lord, that, my lord, she doesn't know whether there was any adoption or not, because from her childhood, my lord, she was.
But she's not natural daughter of this person.
That is what we need to clarify, my lord, because they have given a case number also, CR order dated so and so,
yes.
my lord. So we have to find it out, my lord. For that, my lord, I need some time, my lord. Otherwise, the matter was ready for hearing.
Mr. SD, please find allowed 3 weeks time to obtain for the
1 week, my
instructions.
lord.
2 weeks.
2 weeks, my lord.
Hello, there's a notification. There's a notification, 2010 notification is there.
In your affidavit?
Not in my affidavit, I just want to produce
What does
that.
it say? In your affidavit?
No, my lord. They are just.
What is this?
Give me one copy. Which? What is this?
48, Your Lordship, Rule 48.
Yes, amendment is there, yes.
Yes, Your Lordship. Your Lordship, the petitioner, she already passed the age of 25, Your Lordship.
Oh, that is the first category, my lord.
Yes, first, even first
The first category, my lord. The first
second
category.
she's adopted.
You are married, no?
I'm unmarried, my lord. Unmarried, but she was born in 1989, according to the birth certificate.
Doesn't matter.
My lord, I'm claiming from same category. My lord, may kindly
Doesn't
see,
matter. Yes, that is not important. This is well aware of this. Also, yes, after 2 weeks. Yes.
26.
This is a matter where it appears to be covered, my lord, subject to my learned senior, what he will submit, my lord. My lord, may kindly see, the petitioner herein, my lord, has joined the BSF, my lord, on 29/2/2016, my lord, as an assistant commandant, my lord. Then, my lord, his appointment was confirmed, my lord, on 16/12/2020, my lord, after 2 years, my lord. On 2017, my lord, he was selected to represent BSF as team captain in All India Commando competition, my lord. While he was there, my lord, during a practice session, my lord, he met with an accident, my lord. He fall down and there was an injury, my lord. He sustained injury, my lord. On 16 January 2020, my lord, there was a code of inquiry was conducted, and it was found that it was found and recommended, my lord, that the injury sustained by the petitioner is attributed to the bona fide government duty, my lord, and my lord, for which no one is supposed to be blamed, my lord.
Yes.
That is on page Annexure 2, my lord. The subsequent order which was passed, Annexure 2.
Question inquiry was concerned.
Yes, my lord. Annexure 2, page 36, my lord.
Yes.
Page 36. The relevant page is, my lord, page 37. Therefore, I recommend that A, the injury sustained by so and so is the petitioner, my lord, is attributable to the bona fide government duty for which no one is to be blamed, my lord.
Yes.
Then, my lord, what happened? On 6/9/2019, my lord, a medical board was constituted, my lord. That is on annexure. That was a board was constituted, my lord. On 6/9/2019, my lord, it was said, my lord, that the medical category of the petitioner was given, my lord, which effect from 6/9/2019, my lord. Thereafter, my lord, in between, my lord, I have completed all my courses, my lord. In between.
Where's the medical board?
Medical board, my lord. That, my lord, I have stated in para 6, my lord. May I kindly see para 6. The day upon examination by the medical board, the petitioner has been placed under medical category so and so, which effect from 6/9/2019. In the meantime, the DPC, my lord, DPC was conducted on 28/12/2022, and in the same, the petitioner was assessed as fit for grant of seniority time scale, which effect from 29/2/2020, my lord. And this is a regular phenomena, my lord, where after 4 years, my lord, after joining, my lord, I am entitled to, my lord.
Yes.
Now, my lord, what happened thereafter, my lord? In between, I have completed all the course on 28/12/2019, my lord. 2022, my lord. My name was recommended, my lord. After my name was recommended, my lord, a list was notified, my lord, where my name was not included. That is on page Annexure 3, my lord. Where my name was included, my lord, for STS, my lord.
Where's
but that is on page 39, my lord, Annexure 3.
Where, which number is your name?
The last name, my lord, in page 39. My lord, got it, my lord?
Yes.
Thereafter, my lord, a promotion list was published, my lord, where my name was not included in the list, my lord. That is on Annexure 4, my lord.
This is for grant of senior time scale.
Yes, yes, my lord.
Yes.
Page 43, my lord, Annexure 4, order dated 8 June 2023, my lord. My name was not included, my lord.
Yes.
What? Then I have submitted a representation, my lord, to the Director General, my lord, that is on page 50, Annexure 5. On 19 June 2023, my lord, I have submitted a representation seeking, my lord, clarification why my name was not considered, my lord.
Yes.
On the next page, that is page 52, my lord, they have replied, my lord. They have replied saying this, my lord.
The bona fide gum duty but not active duty.
Yes, my lord.
Then
that has been settled, my lord. By
what is
the
the difference between the bona fide and active duty?
Now, my lord, Supreme Court has clarified, my lord, in one of the case, my lord, I will rely upon that. Thereafter, my lord, what happened? They are taking a shelter of the instruction for medical examination and classification of personal service in the CAPF, my lord.
Yes.
That is in page 54, my lord, 4.14. The serial number, my lord, 4.14. Clause B, my lord.
Yes.
Officer, man who are wounded, injured during the field firing, accident firing, expose of mines or other explosive device and due to accident while on the active government duty in India or abroad will be eligible for promotion in the following space categories, my lord. These are the categories given, my lord. Now, my lord, this case is already been settled, my lord, by the Honorable Supreme Court. Because, my lord, Section 2, if my lord may kindly see Border Security Force Section 2, my lord, Act 1968, my lord. They have defined, my lord, active duty.
What's bona fide gum duty and active duty?
My lord, they are saying, my lord, I was not in active duty. I was in a bona fide government duty, but not active duty. Now,
Section 2.
Section 2, Clause A, my lord, 1A, my lord, of the Border Security Act, 1968. My lord, if I am permitted to read, active duty in relation to a person subject to this act mean any duty as a member of the force during the period in which such person is attached to or forms part of a unit of the force. My lord, then I skip the other things, my lord. Then the proviso and includes the next para, my lord.
Yes.
And includes duty by such person during any period declared by the central government by notification in the official gazette as a period of active duty with reference to any area in which any person or class of persons subject to this act may be serving, my lord.
Where's the decision?
Sorry, my lord.
Where's the decision you said?
My lord,
define.
My lord, this is on 2013 6 SSC, my lord, 333. In the case of state of Jammu and Kashmir.
333.
333, my lord.
Yes.
The relevant para is, my lord, para 8, 9 and 10, my lord. Before this decision, my lord, if we can just go to the notification which has been issued by the central government. Because the section said, my lord, proviso that if any notification by the central government, and there was a notification by the central government, my lord, on 30th July 2000, sorry, my lord, it is 29 July 2010, my lord. It says, my lord, in pursuance of clause A of subsection 1 and of section 2 of the Border Security Act that we have read, my lord, the central government hereby declared that the duty of every person refers
Where
to...
are you reading from?
From the notification, my lord. The next page, my lord, 55. Page 55, the relevant portion is page 56, my lord.
Yes.
Notification dated 29 July 2010. In pursuance of clause A of subsection 1 of section 2 of the Border Security Force Act 1968, the central government hereby declares that the duty of every person referred to in the said clause A serving in the state or union territory mentioned below with effect from the 1st July 2010 until further order as active duty, my lord. They have defined active duty for the purpose of this act, namely, my lord, serial number 20, I was in Madhya Pradesh at that point of time. Now, this has been settled, my lord, in this case, in para 8, my lord, if my lord may kindly see para 8.
Yes.
The expression active duty has been defined under section 2(1)(a of the Act It read as follows, my lord, that we can skip this.
Yes.
Now, my lord, now para 9, my lord, the aforesaid provision make the duty of the nature specified therein to be active duty and includes duty declared by the central government by the notification in the official gazette. From a plain reading of the aforesaid, it is evident that any duty as a member of the force and enumerated in the subclause 1 and 2 that is engaged in the operation against an enemy or operating at a picket or engage or patrol or other guard duty along with the border of India shall come within the definition of the active duty. It shall also be included such duty by the members of the force as active duty declared by the central government in the official gazette, my lord. This is the official gazette, my lord. Now the last para, my lord, para 10, I will be relying upon. The central government notification dated so and so in exercise of the power conferred under section 21A of the Act has made a declaration that the duty of every person serving in the state as mentioned in the said notification for a period of so and so to so and so shall be active duty. The state of Jammu and Kashmir is a serial number 16, my lord. So this notification is very clear, my lord. Now, two more judgment, my lord, I have relied upon. One is of Delhi High Court, my lord.
What is an affidavit, Dr. Muzika? Active duty means what? So after notification, we'll put, how do you read it then?
Well, we have referred to page 28E of my affidavit. Right?
Yes.
The bottom of it, clause B.
Yes.
Officers, men who are wounded, injured during field firings, accidental firings, explosion of mines, or the other explosive devices due to accidents while on active government duty in India or abroad will be eligible for promotion to full executives. Now, in his case, the recommendation was a bona fide government duty. The APS is only wording.
That's it. We'll pass all this back. That definition of bona fide government duty is not nowhere in the Act. Nowhere in the Act. How can you then that definition should be left out, or it should be defined properly by BS authorities to make distinction between active duty and bona fide duty.
Well, DCS duly recommended. DPCS recommended him also.
So whatever, but even then, you don't make a serviceman come to the court for small things like this. It can happen to any serviceman. Yes.
100%.
Yes.
Wait, please, Your Lordship. This is a matter concerning the promotion of the petitioner, my lord, which has been withheld for no plausible
He's serving
ground.
as?
LDA, my lord. LDA in the office of Deputy Commissioner, my lord, West.
At 2 o'clock.
2 o'clock.
41:30.
Can I seek some
Yes.
accommodation today?
We can have it
2:15, yes?
Your Lordship convenience, maybe next week or any time
Any
this
day,
week.
but not your lordship.
Not in the afternoon.
Not afternoon, my lordship.
Okay.
Lordship, I'm extremely sorry if I.
No, nothing. It's only that you have to be alive to the situation. You make a submission, you're a seasoned counsel.
No,
That's
Your Lordship,
it's
17
vacation
like-
time. So you should know, I mean, that is whether it's vacation or you have to verify that. The fact that the order is not communicated to them, that is your fault and their fault also. So then we can't hold the respondents guilty also of publishing the results when it was not to their knowledge at all. That's the only thing. As counsels appearing in the court, your officers of the court, and you have a duty towards your client
Yes, Your
also. That's all.
So we can have this matter next week, my lord.
Next week.
All right.